Good afternoon. And for those of you, or late morning, depending where you are in the country, for those of you who are returning from being with us for part one, welcome back. And for those of you who are joining us for the first time now for part two, welcome to Husch Blackwell's Labor and Employment Day. We have and more topics about crucial labor and employment areas and issues presented by attorneys from across our office coming for you this afternoon. For those of you who are not with us this morning, I am AJ Weisler, an attorney at Husch Blackwell Labor and Employment Group, a member of the Link, who lives in Michigan and is in St. Louis today to be your host. You'll hear from me now and then in between the different presentations as we go through the afternoon. We're excited to continue this day, and as a reminder, as you come in and out of this presentation, you'll see that there is a schedule of all of the events and an agenda for the afternoon that should show up in your screen. If you have questions during this webcast, please click the question button. If you submit that question during the presentation, we'll do our best to respond to you today, and if not, someone will follow up with email if possible. And you'll also see there's a PDF of the presentation that's available for you and a link at the bottom in the materials folder. This program has been approved for HR and legal education. To report your hours, you need to click on the Continuing Legal Education sign-in button that you should see on your screen. And a certificate of your attendance will be sent to you that will include course numbers and also a link that will have the recordings of today's presentation available for you to rewatch or share. Toward the end of the program, if you have an opportunity, please do fill out the survey form that's at the bottom of the screen. We use your feedback to plan future programs and to identify content that's going to be most useful for you. So now we're going to kick off part two. And our first presentation is going to be a repeat from this morning as far as in the presenter, although the topic is fresh. And we're going to hear from Eric Eisenman once again. Now, for those of you who were with us earlier, you know that ahead of each presentation, I'm spending a little bit of time letting you know something about the presenter that lets you glimpse their life as a human being, not just a lawyer. So we learned earlier, for example, that Eric, who is from our Milwaukee office and the leader of our practice specialty group of labor and employment, is also a very talented, well, I guess I assume he's talented, I wouldn't be able to tell, but he can play the French horn. And he does so and continues to do so in various organizations. That's not all he's got going for him, though. He's also passionate for time spent with family, and he's passionate for being creative in doing those activities. And one thing that his family enjoys, and there's actually, I'm going to show you an artificial intelligence and AI representation of him enjoying this activity, but there's a bit of an Easter egg hunt for you, because on our website and on his profile, if you find the right link, you'll see a photo of his family engaged in this activity, and it is wonderful. And of course, that activity is attending theme parties. That's the sort of thing that I thought ended when you hit your mid to late 20s, but for Eric, it's a lifelong passion. Here he is attending a theme party that artificially is representing the Gatsby era, the great Gatsby era even. I thought it was pretty good, but many consider it great. And Eric enjoys going to these parties and dressing up along with his family. And I think it is a good transition also to the next topic, because he's going to be talking about the new reality and the theme of what's happening in the world of administrative law after the Supreme Court's decision that struck down Chevron deference. So without further ado, I will send it to the other studio for the first presentation of the afternoon from Eric Eisenman.
Thank you, AJ. I was wondering how he was going to make that segue. I'm going to start out by being very candid with you that this topic could seem on its face to be pretty dry, but we're going to do our very best to keep you interested and engaged throughout this topic. Talk about how it is going to impact sort of many things that I think you as employers are dealing with. And see if we can work in some theme party or Gatsby references. We'll see. I'm not making any promises. The topic of our session right now is Loper-Bright and the end of Chevron deference, the impact on federal labor and employment law. So I'm going to start by explaining what these cases or concepts are. The Loper-Bright decision is a decision that came down this year from the United States Supreme Court and had a very large impact in lots of different legal areas. But labor and employment is certainly one of those. So I'll talk about that case. I'll talk about Chevron, which is another Supreme Court case, which is overruled by Loper-Bright, and the way that that influenced the evolution of the law over the last 40 plus years. And specifically, we'll talk about what the impact of this decision, the Loper-Bright decision, will be on various different federal agencies that touch the labor and employment space. We'll talk about the Federal Trade Commission, the Federal Equal Employment Opportunity Commission, the U.S. Department of Labor, particularly as it relates to wage and hour topics. We'll relate this back to some of the items that you heard very early today from our colleagues Scott Myers and Joe Glinius. Talk about the Occupational Safety and Health Act and the Occupational Safety and Health Administration and the impact of this decision on that agency. The National Labor Relations Board, which you heard Megan McManus and Mary Ann Zach discuss. And finally, a special impact that I think is interesting and relevant on workers in the gig economy and this concept of employee versus independent contractor. And finally, some takeaways and recommendations and things maybe for us to look for in the future. So let's start with what this case is. Again, the caption or the name of this case is Loper-Bright versus Raimondo. It might be helpful or relevant to just give you a little bit of background about the facts of the case. I really don't want to get too deep into that because, as you'll see, it's sort of arcane. The case essentially involved a regulation that was issued by a federal agency that regulates off-sea fishing. And this agency was tasked with ensuring that the fishing industry was not depleting the sources of fish that end up on our table. So they were empowered to do this through statute, but they were implementing and enforcing various rules, some of which didn't bear a whole lot of resemblance to the statute that provided the power in the first instance. So the case basically involved a rule that this agency tried to enforce, which would require commercial fishing boats to pay for the cost of having government agents accompany these boats to ensure that they were following the rules. So the plaintiffs in this case basically said, the government may have the right to regulate this industry under statute, but that's far different than requiring us to bear this cost. And so fundamentally, it was a question about what the scope of an agency's power is if there isn't a specific grant or specific description of that in the statute. And so on June 28th of this year, the court issued its decision, ultimately finding in favor of the plaintiffs and concluding that this agency did not have the authority to issue that rule. But beyond that, the court went all the way to overturn the agency's authority under what we call the Chevron doctrine. Talk a bit in a moment about the Chevron case. But Chevron USA versus National Resources Defense Council is this case from 1984, which has created the roadmap or framework for us in this area. This decision in Loper-Bright potentially unravels all sorts of existing regulations, and it could reshape the regulatory landscape for years to come in the commercial fishing industry, but also in all sorts of different industries that we touch as labor and employment lawyers here. So Loper-Bright's the decision. Overturning is what it's done. But what did it actually overturn? It overturned this doctrine called the Chevron doctrine. I know some of you on the call went to law school, and if you did and you took administrative law, you will remember that the Chevron doctrine plays a central role in the way that we analyze and interpret federal agency action. Essentially, this case, again from 1984, was an instance where the U.S. Supreme Court established this principle that there are going to be various instances where federal courts, reviewing courts, are going to be required to defer to agency interpretations. So the way to think about it is, in Chevron, the Supreme Court said there's some instances where a federal statute is very specific about what the rule is and very clear. And in those instances, a reviewing court has the ability to read that and make a determination just as anybody else does. But there are also many instances where Congress, despite its good intentions and best efforts, does not speak as clearly as we would like them to about a particular rule or topic, and that the language might be ambiguous. What the Chevron case says is that if the language of the statute is ambiguous, and again, we're going to be able to make that argument in many different cases, that a reviewing court is required to uphold an agency's interpretation. The impact of this is that these federal agencies were given a fair amount of power to issue rules that would interpret or provide guidance regarding language in the statute. So this influences areas like labor, environmental protection, public health. So beginning in the 80s is when you see a rise in the power of what we describe as the administrative state, federal agencies issuing rules that dictate how employers and other businesses have to operate. As I said before, the Chevron doctrine has this very central place in administrative law. It allows parties to defend agency actions against legal challenges. It essentially creates a higher burden for an entity that's trying to challenge an agency action because the court is going to apply this test. There have been some recent challenges to agency actions that might sound familiar to you that were ultimately decided in large part because of the application of this doctrine. So as an example, OSHA recently issued certain masking and vaccination rules during the pandemic. Various agencies like the Department of Labor, the IRS, others have issued rules regarding classification of workers and independent contractors. And there are also a number of recent decisions related to, again, this wage and hour concept on overtime, federal overtime rules. When these decisions are challenged, one of the primary arguments that the agency raises is that, hey, we're dealing with an ambiguous statute when we talk about all these things. And the agency should then be empowered to say what, for instance, salary basis means, or for instance, under the OSHA Act, sort of what the general duty clause or a safe workplace means, and give us an agency wide grant of authority to be able to make rules and regulations. So that was the status quo. And now with this new decision, you've essentially eliminated this concept of deference. Courts are no longer required to defer to federal agencies, even if the statute is ambiguous. The end result of this is going to be legal challenges to these agency rules and regulations. And as I said, Chevron doctrine is 40 years old. Am I doing the math right? 1984 to 2024. There are a lot of agency rules and regulations that have been issued in this interim period that are now potentially subject to challenge. The outcome of these challenges is going to be uncertain because there's going to be a lot more discretion with the reviewing judges and the reviewing courts. There is also some interesting impact on what we are seeing as some very recent federal rules, one of which I'll talk about in a moment. These recently promulgated rules or regulations have immediately been put into question because of this Loper-Bright decision that's been issued in the interim. So the first one of the agencies that I want to talk about here that is likely going to be impacted by the rescission of the Chevron doctrine is the Federal Trade Commission. And I don't want to steal too much thunder from my colleagues, Randy Thompson and Ely Sullivan, who are going to be talking specifically about the FTC's non-compete rule and non-competes more broadly. But I'll kind of just give you a refresher on this rule. You may be familiar with it. Earlier in this year, 2024, the Federal Trade Commission, which, as you likely know, is an agency that's empowered to regulate trade and commerce in many different ways, not typically one that touches the employment law world, issued a proposed rule and then a final rule that would effectively invalidate or nullify existing non-compete agreements in almost all instances. Again, you may know that this is an area of the law that has historically been sort of governed or dictated by state law. But in this instance, the FTC said this is within our scope and jurisdiction, so we're going to issue this rule. The rule goes into effect, or I should say it's published, and then is scheduled to go into effect in September of this year. And it is challenged in a number of different instances. But the primary basis of the challenge, as you can see here on the slide, is that the agency that issued it here, the FTC, has a lack of statutory authority to issue this kind of rule, that it would be an unconstitutional delegation of power to the agency to allow them to touch this area, or that the rule should be considered arbitrary and capricious. The focus or the language in the statute that empowers the FTC to address this area is that the agency has the right to regulate methods of unfair competition. So you might think about that typically as like antitrust considerations. That's a key area that the FTC focuses on. But the key question in this instance is, does unfair methods of competition actually mean or connect or relate in some way to employee restrictive covenants or non-competes? The FTC argued that it did. The challengers argue that it doesn't. And they're emboldened by this Loper-Bright decision. So The impact, of course, is that, a reviewing court no longer has to defer to the FTC's interpretation. The court can make the same, can use its own discretion as to what unfair methods of competition are and whether that applies. It really undermines the FTC's rulemaking authority, both as it relates to this particular rule and I think other areas going forward that might be outside of the clear scope of unfair methods of competition. And as it relates to the FTC rule, again, not to steal the Randy and Ely's thunder, but you will know that rule was temporarily enjoined on a nationwide basis, where there were a number of challenges to that law across the country in advance of that September effective date. But we got a decision from a district court enjoining that rule nationwide. So it's not in effect. It's in a sort of a pause state right now. But this Loper-Bright decision, because it's in place now, and frankly, it was not in place when the FTC issued the rule or published it, makes it even less likely that this rule is ultimately going to effect. So a great example of an area where an agency, may or may not have had authority in the first instance, but this makes it more of an uphill climb. So FTC less likely to be able to regulate in this area in light of this decision is my takeaway here. Next agency I want to talk about, the federal EEOC. Counterintuitively, you might wonder if there's actually a potential for less impact on this agency. Title VII, and you would have heard this in the presentation that Katarina and I did this morning, is the statute that is most commonly addressed or regulated, really enforced by the EEOC. And interestingly enough, that statute only authorizes procedural regulations. So the EEOC, when it issues guidance on topics like, for instance, rights of transgender individuals in the workplace, pregnancy discrimination, other things like that, issue non-binding guidance. So courts have always been able to sort of rely on that for certain purposes, and parties can cite that guidance, but it doesn't have the same power that other kinds of agency action do. Loper-Bright, the case we're talking about here, doesn't actually address judicial review of sub-regulatory guidance. But the status quo, I don't think changes at all. Before, many courts would simply give that some weight and they wouldn't rely on it too much. However, there are certain other anti-discrimination laws that the EEOC is very involved in. The Age Discrimination in Employment Act, the Americans with Disabilities Act are two examples of laws where the agency is granted general rulemaking authority. And the EEOC has issued, or there are regulations that are issued under those statutes where Chevron deference will no longer apply. So there's a large body of case law that exists right now that applies to those statutes. Courts may still rely on those cases the same way they would rely on cases in any other context, but they're not going to get the benefit of Chevron deference. The Pregnant Workers Fairness Act, if you've been receiving the messages from Husch, Blackwell, and our legal alerts, is something that we've been writing and talking a fair amount about over the last year. This is in a place where the EEOC has now issued regulations implementing that rule. And that, I think, is going to be a subject to lots of challenges that are going to be impacted by Loper-Bright. One example is sort of the abortion-related provisions that you see in that act have already been challenged. And my sense is that those challenges have been bolstered by the end of this Chevron deference. So this sort of anti-discrimination context is an area where I am anticipating some change as a result of this decision, perhaps not wholesale change. I still think that we can rely on the body of law that's been developed here. Next area, and an area where I think there will be some substantial change, is the Federal Department of Labor's Wage and Hour Division. So here I think there's going to be a significant impact. If you will have attended some of our seminars over the year, we've often been talking over the last 5-6 years about challenges to the DOL's increases in the salary basis rule, for instance. So, these were challenged during the Obama administration, during the Trump administration, and now during the Biden administration. The department from time to time has sought to increase the minimum salary, for instance, for which an individual would have to earn in order to be qualified as exempt and not eligible for overtime. There's some uncertainty now as to the validity of both the existing rules and some of the new rules that I'm going to mention as it relates to these white-collar exemptions. So there's this pending challenge to the Department of Labor's rule under the Trump administration, which increased the threshold from $455 a week to $684 a week. And I say pending challenge, there was actually a decision from the Fifth Circuit yesterday or very recently that may have affirmed this, but only on a partial basis. So essentially, we've already seen the impact of the Loper-Bright decision on the way that courts are analyzing this. So to put those numbers into real dollars, this was the increase in the salary basis from about $35,000 to about $40,000 in order to be qualified as exempt. This is not going to have, we don't think, a material impact on most of our clients, because in most instances, those exempt or salaried employees are earning more than that, even that new threshold. The bigger question in my mind is going to be how this impacts the attempt by the Department of Labor under the Biden administration to increase those numbers even more substantially. So you may remember that as of July 1st this year, there was an increase in that rule, in that salary from $684 a week to $844 a week. And then there is scheduled to be another very substantial increase in that from $844 to $1,128 a week, effective January 1 of next year. That's going to have, or could have, a real impact, right? That's not going from $35,000 to $40,000. That's going from $40,000 to $80,000 or $90,000 potentially for in order to qualify for the exemption. The Texas court that has analyzed these cases and entered a sort of a narrow injunction actually cited this Loper-Bright decision in granting that limited injunction, showing us that this is going to have an impact on wage and hour. We'll talk a little bit about OSHA, the Occupational Safety and Health Agency. Again, an area where there's a statute, but an awful lot of regulations, and some of which has very ambiguous languages. Most employers, notwithstanding this change, are going to continue to follow the OSHA rules in the same manner they did. But we are expecting a number of significant challenges to some of OSHA's rules, including one that caught a fair amount of attention earlier this year, which is the April 2024, it's referred to as the union walk-around rule. Essentially what it does is it provides some basis for union members to be present during OSHA inspections in a way that they weren't previously able to do. The key language in this regulation suggests that a union member could be a representative authorized by employees. So the language is authorized by employees. Challengers, I think, to that rule are saying, well, that doesn't suggest that outside parties, third parties who don't have any connection to the business are going to be eligible to participate. But OSHA has argued that it could include that. So you're going to see challenges to that rule. There are also likely going to be challenges to the way that OSHA is using its classifications for other than serious, serious, and willful, or potentially the way that OSHA has focused or has an emphasis on multi-employer work sites or instance-by-instance policies. So these are all areas where OSHA has been, how should we say, flexing its muscles, pushing on the scope of its regulatory authority. And when it can rely on the Chevron doctrine, knows that it's going to have a reasonably good chance at succeeding if it's challenged. Under our new legal framework, I think that it's going to face more of an uphill battle. The other thing I want to frame for you here is even if we anticipate that OSHA is going to experience some pushback in this space, one of the consequences there, I believe, is an increase in state-level activity. So as you may know, OSHA is a federal agency, but there are a number of states that have state safety and health agencies. The Chevron doctrine, Loper-Bright, would not apply to those state agencies. So you might still see states in places like California or Minnesota where they're instituting their own rules that wouldn't be impacted. National Labor Relations Board, you heard our terrific colleagues, Megan and Marianne, talk a bit about that. The NLRB has been more aggressive under the Biden administration, relying in part on this concept that we're going to receive some judicial deference. The Loper-Bright decision is going to impact this judicial deference, both as to factual determinations, as well as some ways in which the board interprets terms like employee, joint employer, things like that. I think one area in particular that we might see as a sort of a fallout here is that there could be what I describe here as more of a fragmentation of labor policy. So if instead of sort of a more broad nationwide sense that this is sort of how the agency is allowed to act, here we're taking the power out of the agency and giving it to the reviewing judge. And so what we may be left with is a scenario where different circuits are going to apply different levels of scrutiny or different interpretations of key provisions under the board. The other thing that I think Megan and Marianne mentioned is even in the absence of Chevron deference, there is a separate concept called Skidmore deference, comes from a different case, that would still apply, still gives the board some coverage and a basis to rely on for the position that its interpretation of these rules is accurate. But the key thing to know about Skidmore deference is that it's, how would I say, less valuable or less useful to the agency than Chevron deference. It basically says you have less of a benefit under that concept. So anticipating some substantial impacts here. As we sort of start to wind this down, talk a bit about the impact on gig economy and independent contractors. This has been a very hot topic federally around the country. You think about classification of delivery drivers, of food delivery individuals, all sorts of folks who are gig workers. And all these different federal agencies often have different definitions in the statute about what constitutes a, quote, employee. And I would say, as a general rule, these agencies have been fairly aggressive in arguing that some of these folks who have been drivers, app drivers, delivery drivers, are actually employees, even if the businesses are considering them independent contractors. But those agencies have taken this broader interpretation, and in some instances have been successful in court, in part because the reviewing courts are giving deference to the way the agency interprets this. I think there's going to be a substantial impact. This Loper-Bright decision is going to result in a substantial impact here on gig economy workers. It may create some challenges for unions in seeking to represent employees who are in these various classes. It may create some difficulty for claiming benefits like minimum wage and overtime protections. Because the concept, of course, here is, if you're an employee, some of these laws will apply to you and you're going to be entitled to extra protections and benefits. If you're a contractor, you will not. So I think the net result of Loper-Bright, at least on the margins, is going to be that agencies are going to have a harder time showing that these workers are employees. And employers may have a slightly easier time showing that they're independent contractors. That said, I'll give you the same caveat that I did on the workplace safety concept. This deference doctrine is not going to impact what's going on at the state level. States have control over their own definitions, and state review courts will apply their own deference concept. So that's going to be separate. Let's talk about some key takeaways. So we've spoken about how I am anticipating that there will be greater scrutiny of agency action overall. The court will be the one independently interpreting these statutes that will ensure that the regulatory agency acts within delegated authority. There was an interesting piece that I read about a week ago in the New York Times about certain federal judicial circuits that are taking a more aggressive approach in pushing back against agency power. The absence of the Chevron doctrine is going to empower and embolden federal judges who are seeking to do that. The longer term effect on federal agencies is that they're going to be expecting greater judicial scrutiny when they're issuing, defending, or enforcing regulations. And so what agencies are going to need to do is that they're going to have to, what would I say, develop a more detailed record to prove that they are acting within the scope of their authority. Agencies are going to need to develop and maintain more comprehensive records. You're likely going to see more use of expert witnesses and a more comprehensive and detailed explanation when rules are implemented or enforced. As I've suggested, the use of experts can provide additional credibility and authority to the agencies here. And the agencies are probably going to have to do a better job of explaining their decisions clearly. Rather than sort of taking a shortcut, for lack of a better word, they're going to need to use their expertise and sort of develop that record to justify the actions that they're going to take. It's also important to note, as I said, I may have alluded to this before, but prior decisions still stand. Sometimes when the Supreme Court overturns prior precedent, it will say, this opens Pandora's box, or it's going to allow us to reopen all sorts of decisions previously. To the extent that there are prior decisions by the Supreme Court or by federal district courts across the country that relied on the concept of Chevron doctrine to find in favor of an agency, those remain good law. Similarly, regulations and interpretations that have been previously upheld by prior courts remain valid. And these past precedents remain valid unless they're specifically challenged and overturned. Having said all that, like, you can expect, I think, the floodgates to open in terms of challenges to these regulations. So again, the decisions are going to remain valid. Somebody who previously challenged and lost is not going to sort of get a second bite at the apple. But if a new entity is subject to a regulation issued by an agency, and they feel like, under the new Loper-Bright doctrine, a court should overturn that, they can challenge that. And I think in many instances, they may be successful, especially if they are using a venue that is more hostile towards this agency action. I've alluded to this before, but I think the other thing that this really will result in is sort of creating a new level of importance on state-level agencies and action by state agencies. So if you're going to see, for instance, reduced agency power at the FTC level, or by OSHA, or by environmental regulations, for instance, you are going to see increased activity by agencies at states like California, New York, Illinois, other places that are going to be more historically progressive or employee friendly. So one example is, one of OSHA's initiatives of the last several years was focusing on new rules or new regulations addressing extreme temperatures in workplaces. This is an area where I think it's quite likely that challenges to OSHA's rulemaking authority in that area could be upheld and successful. But even if that's the case, you are likely still going to see activity by state agencies in that space, particularly in these large states that I've sort of flagged here. And so it does, I suppose it's a little bit of a double-edged sword. If you're an employer in an agency or in an industry that's impacted by some of these various agencies, and I suspect almost all of you are, your takeaway might be, this is going to give me some additional room to breathe. It's less likely that an agency is going to take sort of a controversial or expansive view of one of these rules that could impact the way that I do business. And I think that's true to a certain extent, but I also think you have to be mindful of where you're operating. If you're in Missouri, where we are today, if you're in Indiana, if you're in Texas, if you're in Florida, I think you are likely to sort of experience exactly that. More flexibility, less agency action. However, if you also do business in Illinois or California or Wisconsin or Minnesota, many of these state agencies may step in to fill the void. As I was researching to prepare this presentation, I took a look at some various different discussion among both employer and employee advocates. And one of the sort of key topics among unions and employee advocates is that state agencies are going to have to step up because federal agencies will be comparatively weakened. So on balance, I think it's going to be significant, but like all of the things that are happening so quickly, we don't exactly know how everything's going to shake out. It's something that we will monitor, that we will continue to keep you all updated on. With that, I'm going to kick it back to AJ.
All right. Thank you, Eric. Appreciate all of that time shedding some light on Loper-Bright. We are going to be heading to next topic in a moment. And that topic, of course, is our EEOC update, keeping up with the EEOC. I think that's a keeping up with the Kardashians reference. It's a popular reality television show, from what I understand. And we're going to hear from two people who could themselves be the stars of a reality show about that topic, Jenna Brofsky and Tim Hilton, both of whom are joining us today in St. Louis, but normally work for us out of our Kansas City office. And like I mentioned with Eric before, and as I will with everyone else, we will be doing a little bit of information, providing a little information about these two as real human beings, not just lawyers. So, for example, Jenna Brofsky, she is originally from New York City. She's our third attorney today. I would think left New York City for some other part of the country. In her situation, the Kansas City area. Her spouse is an elected state legislator, and Jenna and he enjoy having children and growing children and growing vegetables in their garden. But there's something more important from Jenna's background that she brings to the table. And when I asked for interesting facts about my colleagues to talk to you all about today, more than one person immediately told me that Jenna has a reputation in the Kansas City office, possibly broader than that, of being someone who really, really cares about the flavors of certain foods. So this is an AI image of Jenna added to what AI considers what a food critic would look like. So that's somebody who's holding a salad and looking critically at some member of waitstaff. But as I dug in deeper to find out if they were complimenting Jenna for having a discerning palate, for being somebody who can identify sort of the best of the foods, it became very quickly known to me that, in fact, what they were telling me is that Jenna, being from New York City, has strong, immutable opinions about the quality of bagels and pizzas in the Midwest. Apparently, not one is up to her snuff. She spends her time complaining about them while, I guess, also still eating them, and then eventually finding her way back to the Northeast to get a slice of pizza or a bagel that meets her specific palate. So there is Jenna demonstrating the two foods that bring her joy, presumably in some borough of New York where they can only be found. Also, between those two photos, AI decided that Jenna had a real hair growth. The next person you're going to hear from or with Jenna is Tim Hilton. So Tim Hilton is also from our Kansas City office. He is a native Missourian. Like myself, he's from Southwest Missouri originally. And like someone from Southwest, as you can expect, there's not a lot of interesting background or information about him. But what he is, or one thing he does have, is that he is an internet star, genuinely. So you may be familiar with memes. It's a word that was made up not too long ago, I don't think, and it's meant to be some funny thing that gets sent to you by text message or link on social media, and then you open it and you chuckle. And if you're a good person, you let the person know who sent it to you that you thought it was funny. And if you're me, you never respond to it ever, and they wonder if you received it or cared about them at all. But we all care about Tim, and he is a meme star, specifically a cat meme. So here's what AI says a man who's a cat meme star, specifically Tim as a cat meme star, looks like. It's horrifying and not the sort of thing I would share with anybody except for apparently you all. But I also think it's only fair that we show you the actual meme that brought Tim his internet fame and why he goes viral periodically. And that is a meme involving Tim and his cat. And if you can't read that text, it says, when your husband and cat share a birthday, and then there's Tim, he's the husband in question, and he's holding a cat. So Tim Hilton, cat meme star. This version of it, which was out there on, I believe, Instagram, was liked, a couple 100,000 times. I've seen it on the front page of Reddit. I've seen it bouncing all over the internet. And if you zoom in on the cake, you'll understand exactly why, because the cake really demonstrates that Molly Hilton is the cat meme star, because it says happy birthday to Molly, and then also Tim, and Tim, sorry, in the small font, understanding who, at least in Tim's spouse's perspective, is the more important. And of course, Tim's fame does not just extend to the corners of the United States. He's actually gone viral overseas. One of our colleagues who frequents Asian social media sites found Tim suddenly and clarified that this was in fact him, and has been translated. So maybe someday he will show up in your feed, hopefully for this reason and not something more nefarious. But he's about to show up on your screen because I'm going to send it to that studio and to Tim and Jenna.
Thanks, AJ.
always a pleasure. And Jenna wanted to clarify that our Midwestern pizzeria clients are wonderful.
Absolutely. Yeah. Thank you, Tim. Today's presentation is called Keeping Up with the Kardashians. The EEOC. Sorry, Tim. We're not going to talk about Khloe Kardashian's closet again. Sorry about that. So let's dive in, if we will. We're going to start with what is that federal agency called the Equal Employment Opportunity Commission? How were they created? What do they do? What have they been doing? Because they've been really busy and it's affecting our workplaces. So we'll talk about the charges, the pre-litigation and litigation matters. We'll talk about the rulemaking that EEOC does periodically and has done in the past year. We'll talk about some enforcement guidance that the EEOC provided. And then we'll walk through some situations with the mindset of the EEOC. If this were to be before the EEOC, what are they going to consider and what should you as employers be thinking about? So here we go. The EEOC is a federal agency that was created by statute by Title VII of the Civil Rights Act. The EEOC's mission is to prevent discrimination in the workplace, and it applies to job applicants and to employees. I want to highlight that because we often forget if somebody is applying for a job and they ask for an accommodation, for instance, they'll still be protected by Title VII. So the EEOC is a 5-member body. There's currently a vacancy and there's staggered terms, which means that after the election, the new president will have the ability to really define the commission and the priorities that the commission will have moving forward. The EEOC's federal laws that the EEOC interprets are broad, and they protect discrimination because of a bunch of protected classes. They're listed up there on the screen for you. We have race, religion, color, sex, national origin, age, disability, and genetic information. I will note as to age, for instance, under federal law, the protection applies to employees ages 40 until they stop working. Other states have it differently. So there are states where you can file an age discrimination claim if you're 25 or 35. There are also states like Missouri where age protections end at age 70. So that's a gentle reminder to also be mindful of your state-specific laws in addition to federal discrimination laws. Now, this presentation is about the EEOC. It's also worth noting there's another federal agency that regulates your workplace, and there's more than one, but there's another one that overlaps, the Department of Labor. The Department of Labor will be the one to handle inquiries about FMLA or USERRA or wage and hour law, so be mindful of that as well. So the EEOC was created from Title VII of the Civil Rights Act, but it enforces more laws than just that. We also have the Pregnancy Discrimination Act, the Pregnant Workers Fairness Act, the Equal Pay Act, and I'll put a star next to that one because, as you'll see in a second, that's part of the EEOC's strategic plan. And I'm already seeing plaintiffs' counsels really emphasize to the EEOC, hey, we're making an Equal Pay Act claim. As a reminder, the Equal Pay Act prohibits discrimination in pay on the basis of sex. The EEOC also enforces the Americans with Disabilities Act Title I, which is the employment-related section, and other laws. Now, these laws have been amended to permit jury trials for claims brought under these, and also to allow for collection or recovery of compensatory and punitive damages. Next slide, please. So this is the strategic plan I alluded to earlier. There's 6 priorities that the EEOC has listed. The first is eliminating barriers in recruitment and hiring. And the EEOC is focusing on underrepresentation in certain sectors. And to that very point, this week, the EEOC put out a new report about the high-tech industry and underrepresentation there. So take a look at that. Another priority of the EEOC under the strategic plan is protecting vulnerable workers and persons from employment discrimination. You're probably asking who's a vulnerable worker, and that's a very good question. Some of the populations include Indigenous people, temporary workers, LGBTQ population, and immigrants. The third priority is addressing selected emerging and developing issues, which is kind of like a catch-all, but it of note includes claims for discrimination based on long COVID, and also claims of pregnancy discrimination under the Pregnant Worker Fairness Act. Advancing equal pay is the fourth priority, as I mentioned. We have preserving access to the legal system and preventing and remedying systemic harassment. What does the EEOC mean by systemic harassment? They're referring to harassment that is a pattern and practice in the workplace. You may be familiar with that terminology. Next slide.
Thank you, Jenna. And I'm going to talk a little bit more about some of these options under the EEOC's 24 to 28 strategic plan. Specifically, we're going to talk about charge prioritization, selection of litigation, and even the amicus process and the ADR process. So in the charge prioritization process, EEOC is going to be looking at potential meritorious charges that align with the strategic enforcement plan. So a lot of the points that Jenna was just making really are going to be those kinds of charges that EEOC is going to be focused on. And I think Jenna made a great point in terms of charging parties counsel or charging parties themselves being aware of that and making EEOC, making sure to emphasize one of those points to EEOC, because I see opposing counsel who handle the EEOC different ways. Sometimes if a person is represented by counsel, it's just a race to get the right to sue letter in order to go to court, and the EEOC process is treated much more like a rubber stamp by the charging party's side of the case. But I think we're going to see an uptick in charging parties counsel using the EEOC as a means of getting free discovery. Because if you can show to the EEOC, hey, this is one of those cases that your strategic plan, that your general counsel is wanting us to push, then they can prolong the process, prolong the cost for the employer, and get as much free discovery in the case before they have to go to court as possible. Case selection for litigation and amicus briefs, a friend of the court brief that they might file with the Supreme Court or a court of appeals is probably not something that's on most employers' minds. It's probably not something that's going to have as much practical impact as other things EEOC is doing. But of course, the courts are going to look very closely at EEOC's position when they're taking a position on a legal issue in a friend of the court brief. And conversely, if EEOC decides not to file a friend of the court brief or to not take a position on a certain legal issue, I think you're going to have judges at the circuit and Supreme Court level that are going to take that to heart and consider whether this is an important issue in the executive branch's mind. And then finally, there's always an encouragement of ADR, but I think, and that's alternative dispute resolution, of course, but I think we're going to see that more and more in this strategic plan. In fact, just recently, I've had numerous EEOC investigators and mediators reach out to me explaining that, hey, it's the end of our fiscal year, which I guess may be September 30th, and we need to make decisions about whether we're going to send this case over to enforcement or whether we're going to leave it in mediation. So we're already seeing the effects of a lot of those issues. And in addition to the strategic plan, I'm going to talk a little bit about the general counsel's focus. General counsel Carla Gilbride is appointed by the president, confirmed by the Senate to her role as the general counsel. She has her own priorities in terms of what she's going to be pursuing. And those are, I'll talk a little bit about each of them, but hiring practices, tracking AI bias, to call back to some of the stuff Shauna was talking about in her presentation a bit ago, reintroduction of the mandate of component 2 of the annual EEO1 submissions, and defending and pushing the new Pregnant Workers Fairness Act, the PWFA. So on the hiring point, like, I think we always, counsel employers that it can be a little bit harder to make a failure to hire case, other than in a situation where the employer has documented some inappropriate comment or made some inappropriate posting in what they're advertising the job. But EEOC is going to be focused on this, so be on the lookout for emphasis on failure to hire claims. Tracking AI bias is a really interesting thing that EEOC is going to be looking at. And in large companies, and we're going to see it trickle down probably to all sorts of employers, are going to be utilizing technology and artificial intelligence in order to get through resumes, in order to watch interviews. If you have hundreds of candidates for a particular job, you've got to find some good way to efficiently find the right people, find who should be the final candidates. And of course, that's important, but EEOC is going to be tracking potential bias in the AI process. And I wasn't sure exactly what that meant. So in reading up a little bit more about it, for example, if you're doing a video interview and you're using AI to try to find the best candidates, AI may be taking certain facial expressions, certain vocal tones, certain accents, and may be downgrading those people based upon their facial expressions or their accent, which of course may have a cultural impact. Reintroduction of component 2 of the EEO1 form. EEO1 component 2 requires a snapshot of pay data based upon the categories that are reported under EEO1. And from about 2016 to 2018, there was a component 2, and Ms. Gilbride wants to bring that back. And there are some states, notably California and Illinois, which are requiring that already. This stems from, as Jenna was talking a little bit about the tech industry, some major pay issues for companies like Blizzard or Riot Games or LinkedIn. And then finally, the Pregnant Workers Fairness Act, which we're going to be talking a lot about today, being such a new law and one of the most recent and in a long time federal statutes on employment discrimination. EEOC obviously has that as a priority and something they're going to be looking at a lot. I know this text is very small, but I wanted to just give a few comments about the statistical breakdown of what we see in the 2023 EEO charges. There's a little bit over 81,000 charges in 2023. I did a little bit of checking, and that's up significantly from even 10 years ago. As you might expect, if you deal with the EEOC or state corollary agencies, retaliation is the number one charge. That's the 56.8% slide. I'm not a math whiz, but I can tell you this adds up to well over 100. So before AJ calls that out, I wanted to note that because, of course, charges are going to have numerous different factors in them. Any type of retaliation under Title VII is the 39% one. And then when you get down to non-protected activity, but a protected status, disability is the 36. So I thought it was interesting. That's consistent with what I see in my practice, that disability claims are the most common ones. I always counsel clients that this can be one of the tougher areas to navigate in the accommodation process. And then in lots of ADA cases, you're going to have the confluence of FMLA and even workers' comp. And then race and sex are the 33 and the 31%. And then I thought it was interesting, age is the 17.4%. It seems like I see a lot more significant and concerning cases of age discrimination, even though it's fairly low on the statistical breakdown. And I think Jenna and I talked a little bit about this, and I think probably those are cases where the cases get higher value. There's higher sympathy value. There's higher sympathy factors for employees in some circumstances who are making an age claim, and being people who are later in their career. They may be higher wage earners. So those are kind of what the issues I see there. I just wanted to call out a few more of these. Equal pay is very low at 1.2%. We'll see if that gets bumped up a little bit. But of course, you can make effectively a pay discrimination claim in a sex case under Title VII. But it'll be interesting to see if EEOC's focus on the Equal Pay Act leads to more formal Equal Pay Act claims. And then just a few little tidbits on the litigation. They filed 52 lawsuits this year through the 15th of August. Apparently May, something was in the water in May. So they had almost half of those lawsuits in May. Watch out if you're in Georgia, because EEOC is getting after it in Georgia. That's the most litigious state. There's increases in Title VII claims and ADEA claims, but there's a decrease in ADA. Now, I know as you're looking at this, you're seeing 52 lawsuits. That doesn't sound like some astronomical number. And I'm going to talk a little bit about more about this in the next slide. But of course, that doesn't include any cases that went through the conciliation process that they elected not to go to litigation on because it settled, or they just elected not to for whatever reason. And again, these numbers, this talks a little bit about the settlements that those 52 lawsuits have had. And these numbers don't, if you have ever had the pleasure of dealing with a lot of discrimination claims, these numbers might not jump out at you. The highest is 115,000 and the lowest is 20,000. And I always have that reaction when I get these EEOC press releases that talk about the latest $45,000 settlement that they reached, which oftentimes is probably on the low end of a garden variety settlement in an employment case. But unlike when you're settling with a represented party, EEOC adds in all sorts of other things. You're going to have 2 to 3 years of monitoring, required training, required postings. You're, of course, going to have that press release, the email blast from the EEOC, which nobody wants to be the employer that's named in that. And you're going to be effectively putting yourself under EEOC jurisdiction for the next 2 to 3 years if you get into one of these conciliation process or lawsuits with EEOC.
Thanks, Tim. So in addition to the litigation that we've been talking about, the EEOC from time to time promulgates rules, as Eric started to mention. So the most recent rule, the one we're going to focus on today, is the rule that came into effect this year under the Pregnant Workers Fairness Act. To get to that rule, the EEOC had to go through a process where they had to provide notice, opportunity for commentary, and then a final rule. There's a lot of comments that were provided. Many of them dealt with whether employers would have to accommodate employees' abortion care. The rule itself is focused on what accommodations an employer needs to provide during the gestational period, during the 9 to 10 months of pregnancy, and postpartum as well. And postpartum doesn't have there's no a certain end time to that. As I said earlier, the EEOC is one agency. We also have the DOL, and in terms of postpartum, this is one area where both agencies are kind of overlapping. You may have heard of the PUMP Act, which requires certain space and time breaks for employees that stems from the Fair Labor Standards Act. The EEOC is also enforcing similar rules, but they're coming from the Pregnant Workers Fairness Act, because that act requires accommodations to women postpartum. So, like I said, the focus of the rule that the EEOC promulgated and is now a final rule is accommodations. The EEOC's rule has a few different categories, and the first category are what the EEOC considers accommodations that in virtually all, not my language, EEOC's language, would be reasonable accommodations, because at the end of the day, accommodations have to be both reasonable and they can't impose an undue hardship or burden on the employer. And those accommodations include things like allowing an employee to have water or food so that they don't get sick while they're pregnant, or allowing an employee extra breaks to go use the bathroom. What is really different about, well, I'll step back and say this, because pregnancy is inherently time limited, the EEOC has taken a somewhat different approach in terms of regulating accommodations. So the EEOC has said, yes, there may be a situation where this employee can't perform X duty, can't lift this amount of weight, but at some point in the near future, the employee should be able to do so. And therefore, you, employer, must accommodate it. You must consider removal of an essential function. And that is different than the analysis that has been and continues to be under the Americans with Disabilities Act. So I do want to emphasize that there's a difference in the accommodations for people who are pregnant. In both cases, you should be undergoing what's called the interactive dialogue. So having that conversation with the employee, but it's going to be a little bit tricky, and we should be mindful of this new mind frame. Now, this week, the EEOC, like we said, they're very, very busy. They filed their first lawsuit under the Pregnant Workers Fairness Act. So I'm going to take a moment and just tell you about that case and what they claim. In that case, they're alleging that the employer failed to accommodate a pregnant employee because, in the allegations, she requested a job change, and the employer instead required her to take unpaid leave, and then she ultimately resigned. So what's interesting about that case, first and foremost, is that, like I said, accommodations are a little bit different under the PWFA than the ADA. Under the ADA, you may be familiar with unpaid leave as a reasonable accommodation. And that is still possible under the PWFA, but the regulations state that you can't require a pregnant employee to take unpaid leave if there is a reasonable on-site accommodation. That's the first point. The second point this case makes is that the claims are brought under both the Pregnant Workers Fairness Act and the ADA. In this situation, it appears that the employer may have provided ADA paperwork to the employee who was pregnant. That's also a difference because in most cases, pregnancy at some stage of the pregnancy is obvious. And so the EEOC is claiming that by providing the ADA paperwork and requiring the employee to provide a doctor's note about her medical condition, the employer has violated the prohibition on medical inquiries. So stay tuned. That's a federal case in Kentucky, and we'll let you know how that plays out. The last point I want to make about this rule is that it doesn't replace more protective federal, state, or local laws, so be sure to pay attention to those as well. So there have been a few challenges to the PWFA, but it's largely intact, and employers should follow the EEOC's final rule. Hopefully you've been paying attention when Eric went and he talked about the impact of the Loper decision. It remains to be seen. The last update for EEOC rulemaking I'll touch on is that in 2025, we expect a new rule related to EEO1 filings. As Tim said, that's a priority of the GC.
Thanks, Jenna. I'm going to talk a little bit about the recent EEOC guidance that was issued on harassment. This was the first time since 1999 that EEOC guidance had been updated on hostile work environment issues. And you can imagine there's been significant changes in our world since 1999. There was an effort to change, to update this guidance in 2017. Due to changeover of political administration, it was not covered. I'm going to skip ahead to talk about a few of these things, but these are some of the issues that are outlined in that 2024, April 2024 guidance. Specifically, one of the most important things to talk about is the expanded sex-based harassment to cover various issues, largely in the LGBTQ community following the Bostock decision in 2020. As you probably recall, that's a 6-3 Supreme Court decision, which ultimately clarified the fact that gender identity and orientation, sexual orientation, are part of the protection against sex discrimination under Title VII. So, and you know, I had those types of cases for several years before Bostock. We had those types of settlements. So it wasn't something that was unheard of, but the Bostock decision and now this type of guidance from the EEOC clarifies a number of points. Specifically, it talks about outing, the idea of disclosing an individual's orientation or gender identity without their permission. The idea of misgendering, the intentional and repeated use of the wrong pronouns or the other gender identifiers to refer to someone. Sexual orientation harassment, one of the points of the Bostock decision was that the reason this falls under sex discrimination is that it's ultimately discrimination or harassment against someone because they don't comport with many individuals' idea of what a man or woman should be. And then finally, gender identity, the denial of access to a bathroom or other sex-segregated facility consistent with the individual's gender identity. So we have a number of hypotheticals that we're going to talk about here today. And the first one is right here. So we're going to be talking largely about what would EEOC look for in this circumstance. And these are largely taken from real cases. We've made some changes here and there to make them a little bit more interesting. But the idea of here's a real case and how do we think EEOC would look at it under its 2024 status. So in this case, Isaiah, a customer service rep at a financial services firm, alleges that he was subjected to harassment on his national origin by Zach, his coworker. Isaiah says that last winter, Zach became increasingly hostile, shoving him, threatening him physically, and that Zach's position is kind of that this misconduct started shortly after a disagreement during a league basketball game, during which Isaiah benched Zach and didn't play him as much as Zach felt he clearly deserved. So, Jenna, we'll talk a little bit about what would EEOC look for in this context.
Yeah, absolutely. So in this case, we're talking about coworkers, and that doesn't matter because harassment can come from anybody and everybody that touches the workplace. So it's not just supervisory conduct, it's also my peers' conduct, the vendor's conduct, my client or customer's conduct. So the EEOC is not going to throw it away because it's about a coworker. What the EEOC is going to focus on is a link between the threats and harassment, the treatment, and Isaiah's protected category is, in this case, national origin or color. Now here, the timing really matters because it seems like something changed. Zach and Isaiah were friends. There was a basketball game. Maybe Zach was hogging the ball. Maybe he didn't understand like the defense strategy. I don't know. Point being, you got to figure it out because the EEOC is going to try and link that behavior to a protected category. So what you as the employer and what the EEOC will do is conduct some kind of investigation. The EEOC can and will ask for additional information, can and will interview employees, including other employees who are not currently involved in the situation. So again, the EEOC's focus is going to be on why is Zach treating Isaiah in this way? Is it because of a protected characteristic?
Yep. And in this actual case, employer got summary judgment, which we always like to see, based upon the idea that this was a personal or a company politics type issue. It would be interesting to see 20 years later if they dug down into it and found out was Zach treating him the same way as other people that he'd had conflicts with at work. So next hypothetical is this one with Julius and Murphy. Jenna?
Yeah, I'll read this one. Julius, who is Black, works on a line operation crew for a pharmaceutical manufacturer. All line crew members are Black, and they're supervised by Murphy, who is white. Murphy frequently refers to himself as a zookeeper, and to the crew, including Julius, as my animals. Murphy does not refer to members of other line crews, which are comprised of non-Black employees, as animals. Likewise, Murphy does not refer to supervisors of those other line crews as zookeepers. Tim, what is the EEOC going to do with this one?
Yeah, this one is a little bit more on point, a little bit more concerning. It would not matter to anyone, and it should not matter to you doing an internal investigation, or it's not going to matter to EEOC that Murphy is going to take the position that, well, I just meant, that these are strong guys, they're tough guys, whatever. This is 2024. Nobody can realistically claim that they don't understand, a reference to, African Americans as zoo animals as being race related. So Murphy's idea of just saying, "Oh, I didn't mean it like that," is not going to fly. But EEOC is going to look for, obviously, the link between his behavior and a protected characteristic. They may find a link based upon that, even though he's not directly saying a slur or saying anything that is express about race. And this is not from my case, but I handled a case that was not nearly as aggressive as that, where the supervisor was using the expression, "not my circus, not my monkeys." And of course, his position in the case and when in the internal investigation was that just meant things are chaotic. I don't mean anything about any individual person. But EEOC would definitely look closely at that sort of a situation with those sorts of words being used. And in our final hypothetical, we're going to talk about Christina. She's a graphic designer experiencing pregnancy-related morning sickness. She's getting accommodated due to that by permitting her to work remote for 3 days a week. Her colleagues complain that it seems like pregnant women are getting all these special perks and privileges, that she can just kick back and relax at home on the couch and collect a paycheck. Christina's coworkers sound really, really nice.
Not like my coworkers.
Yeah, not at all like that,
no.
yes. And people are complaining about her being given a new account. If she's so sick, why is she getting put on this important account? So with, expanded sex-based harassment guidance, PWFA, Jenna, do you want to talk a little bit about, how they might look at that?
Yeah. And we talked a lot about like the accommodation side of things and the new rule that was passed. But at the end of the day, there's also another section of the law that says you can't discriminate. You can't harass your coworkers. And I think these comments on their face would be easily tied to a protected category here, sex. This is a good reminder to conduct training to all your employees on what's appropriate workplace conduct, acknowledging, that pregnancy is a little bit different than some of the other medical conditions that we'll be talking about. It's more visible, it's often celebrated, so it's a little bit different. But I do think the EEOC would find these kind of comments concerning, and I think a lot of education and training would be helpful for your workforce here. We're kind of coming to the end of time, Tim.
Yeah.
So.
Absolutely. And yeah, we have to cut for time the guidance on harassment of coworkers with AI-generated images. So the Weisler Doctrine, as I'm calling it. So you can keep up with all of our various publications, our newsletters, LinkedIn. When these enforcement guidance are finalized, we're going to be publishing about that, I'm sure. And then finally, what can we look for in 2025, Jenna?
Yeah, like I said, we have that first lawsuit already. We are going to expect to see both the new rule and guidance litigated and cited by courts. Charges and lawsuits brought both by the EEOC and individuals. Emphasis on equal pay and pay transparency, and in fact, new commissioners. So we'll see a different makeup of the commission. Thank you all for your time, and we're going to hand it back over to AJ.
All right, thank you very much. I appreciate all of the guidance. I'm sorry that I didn't get the details on AI-based coworker harassment, but that's not something that I likely would have listened to anyway. Speaking of which, we're gonna talk about our next two presenters. So the next presentation we're talking about is titled "The Looming September 4th FTC Rule Regarding Non-Competes. What Just Happened or Didn't?" It's obviously after September 4th right now. So as we think about this, it's kind of like doing like a Y2K presentation sort of in mid-January of 2000. And so we're going to find out what happened or didn't in a moment. But before we do that, let's learn a little bit more about our friends Randy Thompson and Ely Sullivan. So they are both attorneys here in St. Louis. Randy specializes in issues like these non-compete litigation matters that he's going to talk to you about. And he is more than just an attorney, as they all are. And so we have an AI photo that we're going to show you for each of them that will represent some aspect of their person that maybe doesn't just jump off of their firm bio page or their LinkedIn. So for those of you who weren't here earlier or didn't hear, I am originally from Missouri, worked in our St. Louis office when I was a new attorney, and then I have worked remotely, and I'm currently part of the Link, which is our virtual office, and I work for the Link in Central Michigan, and I have told most people that I have done that because I'm supporting my wife's career, and she currently is working in Central Michigan, so that's where I am now. And that is, obviously only part of the story. I think a more direct or maybe a simpler explanation is I used to work with Randy Thompson when I was in St. Louis pretty frequently. And I think like most people was looking for the first opportunity I had to then move to Michigan. And it's not because of any negative aspect of Randy's personality. He's just an intimidatingly competent person who makes you feel, a little bit less than. Ely thankfully is up to the challenge. But I think it also affects his family as well. Because one thing that you may not know about Randy is that he has a daughter. That daughter is married. And when that daughter got married, she took the first opportunity she could to move overseas. So Randy Thompson is a transcontinental father-in-law. That's Randy. He's tired on another flight across the ocean to Germany to visit his daughter where she lives with her husband. I don't think that she and I or the brother, his son-in-law and I have confirmed that we were both motivated to live where we live by wanting a little distance from Randy, but I wouldn't be surprised if that were the case. And of course, he's not presenting alone today. With him is Ely Sullivan. Now, Ely is from St. Louis. She is the child of two prominent St. Louis judges and lawyers previously, and now she is herself rising in those ranks. Again, why she feels so comfortable, not basking in, but standing up to the shadow that Randy casts. Now, she has interests that go beyond just being a lawyer. One of those interests is her pride in the great city in which she's from, St. Louis. And on her firm bio, she identifies a love for St. Louis and a love for what else you'll see in this AI image of her, St. Louis and pirates. Now, I'll admit, after I made this slide and I was doing some quality checking of my material, making sure that I didn't state any falsehoods or make any misrepresentations to you, I realized that there was a slight misreading of her bio, which in fact said she is passionate about Pilates, not pirates. Makes about as much sense, I think, as pirates. But the AI image of a pirate in St. Louis was just too good to take out. And so here it is. So hopefully maybe this will spark a passion in her, or maybe she will just continue with her Pilates preference. So you may also notice that I have not yet shown an AI image about myself. I've been sprinkling in little biographical facts where I can in ways that will hopefully endear me to you, the audience. But I didn't do an AI photo of myself because I tried, used the engine, put in the prompts, tried to be thoughtful and non-discriminatory in my phrasing. And everything that came out just wasn't quite right. Most of the time, they just weren't getting like the abdominals correct. And that's not to say that they made them look better or worse. They just weren't right. And I, being the principled person that I am, would hate to send anyone in the audience off with the wrong impression of my abdominals. So I think we will stick to no AI photos of me. Sorry to disappoint anybody. You're welcome to throw together what you can with whatever prompts you want to use. Share them with whomever you'd like, but please don't send them to me. And with that, I'll send you to the changing world of non-competes.
Thank you, AJ. And in case anybody was wondering, no, AJ is secure in a locked room with security outside of it, which is why he's so bold. But the day is very long, and that will change at some point. Good afternoon, everyone. Ely and I are here. I almost said Eli again because everybody calls her Eli. Ely and I are here.
It's fine. Don't worry about it.
Yeah. To talk,
ARG,
Yeah. Talk about non-competes. So this was an interesting one to prepare for here because, for many of you, kind of the elephant in the room is there was the looming Federal Trade Commission ruling trying to invalidate largely non-competes going forward. And so that had a September 4 date on there. And so we thought we'd mention up front, for those of you who aren't aware of that, and we'll touch on this a little bit later, but that rule was stayed by a federal court. So we basically just scrapped everything that we were going to talk about and had to redo it. And while I was going to talk about my impending vacation to Germany to visit my daughter, who loves me very much, we thought maybe the better use of our time would be, let's use this to give a little refresher and talk about the current state of non-competes and offer you some best practices on a go-forward basis. So we're going to talk a little bit just, about non-competes. Many of you may be familiar with it, but, there might be some misconceptions out there. We just wanted to kind of level set on this a little bit, talk about state trends, because with the FTC rule stayed, we're still largely under state law for all these non-compete matters. We will talk about the latest on the FTC rule. And then again, we're going to talk a little bit about best practices for employers there. So what is a non-compete on this? We've got it up there on the screen for you. It's typically an agreement between an employer and employee, where the employee agrees not to compete with the employer, both during the employment and for a period of time after the relationship ends on that. What does that mean? I mean, the rub there is the word compete, right, in there. And we're going to talk about that and break that down a little bit on what that really means to compete on this. I mean, overall, I want you all to understand non-compete is a matter of equity. So it's a little bit of a different animal than just a typical contract claim. It's really to balance the interest between the employer's interest in protecting its confidential information and protecting its customer relationships, among other things, versus employee mobility and the employee's freedom to go out there and engage in employment. And that's where the friction comes in, and that's where we'll kind of concentrate on some of those differences. And keep in mind, on a non-compete, it's to prevent unfair competition. So typically, to get a non-compete enforced, you have to be preventing unfair competition, not just simple competition out there. And we'll talk about what that means in here. Now, keep in mind, too, that we're going to concentrate on the employment relationship in this, but keep in mind, this can apply to some other areas in here. So, for example, in a sale of business, frequently you may have a non-compete that is part of a sale of business contract. Even once in a while, you might have it in a consultant agreement. It's pretty rare, but sometimes you may have it. Also, in a stock award or an equity agreement, you may have a non-compete or other restrictive covenants that are in there. But for purposes of today, although some of those same concepts and doctrines will apply, we're going to really be concentrating on the employment relationship. So the benefits of the non-compete, it's to protect the employer's investment in their workforce, right? I mean, you're doing this to try to keep retention, to protect the information that you give employees, to protect those relationships that you give your employees to on those situations. And obviously to protect the confidential information there that you have for your employees, to protect that information. And I kind of see the overarching, and think about it in this way in two respects. You've got other laws out there. You've got maybe confidential information agreements. You've got trade secret protection under statutory, federal, and state law out there. And that's great, and that's helpful. But a non-compete is to really prevent the damages before it occurs, right? A lot of times what you'll see in trade secret litigation is after the fact, where if a trade secret's used or disclosed, you may have damages, and that's all well and good as well. But a non-compete is to prevent what we call the irreparable harm. It's to prevent it from happening in the first place, to get ahead of it, and to stop the person from going to a competitor and working in an improper capacity and taking that information. I'd say the second part of that is, they can be very effective. I do a lot of this, as AJ said, and so does Ely. And, most of these cases don't get to litigation. But there's a lot of processes that are involved in a non-compete. And I'm sure many of you have dealt with this internally in your companies, where you may have employees with non-competes, or you may be looking to hire somebody with a non-compete. There's not too many employers that don't take them very seriously. I hear all the time anecdotally from people not in the legal field that, non-competes, they're not enforceable, are they? Nobody ever enforces those. And we all know that's not true. But I think they're taken very seriously. And even if matters don't get to litigation, I think they serve a good deterrent factor, and they serve a good incentive factor, both to your current workforce, for your competitors, and those who are out there. So I'm going to switch it over to Ely now. She's going to talk a little bit about the states.
Yes. So as Randy talked about, non-competes are really important in an employment context. So we see there's a lot of state differences, but a big trend is the narrowing of non-competes. So we're going to go into some of the state trends that we're seeing right now. So non-compete agreements are governed by state or common law. The enforceability varies significantly among states and industries. So some states like California have adopted statutes rendering non-compete agreements void for nearly all employees with very limited exceptions. Other states have enacted restricted covenant statutes rendering non-competes unenforceable depending on the impacted worker's earnings, as well as consideration, notice, and other factors. And a few other states have introduced and even enacted bans for certain industries, such as healthcare workers. And we're going to discuss some of these state differences and these state restrictions. So first, there are 4 states that have full bans on non-compete agreements. There's California, Minnesota, North Dakota, and Oklahoma. If I was a betting man, I would have never guessed North Dakota or Oklahoma, but here we are. And one that's pretty obvious is California. In California, employee non-compete agreements restricting post-employment conduct are generally void and unenforceable. The latest California statute has a private right of action for workers, as well as making non-competes void against any employer who tries to enforce a restricted covenant, regardless of where the agreement was entered into and where the employee worked. So typically, we're looking at what state law applies. And so generally, we look at where the employee works, where is the work focused. And so that's a good starting point, but it's not always necessarily a guarantee or 100% clear. So it's important to look at where the employee generally performs services, but that's not always the last step in the process. And again, this is really important, as we know, with post-COVID world, working from home, remote work, where are our workers working? And so that's a big consideration with these non-competes. And as I mentioned, there are also restrictions with industry and income-specific restrictions. So it may not be appropriate or enforceable in all industries. And some states are regulating the enforceability of non-competes in certain industries by state statute or regulation. These industries can include the legal profession, the healthcare industry, as well as new sectors that we've not necessarily seen before, so construction or technology sector as well. And then additionally, there are income thresholds where, for instance, for Colorado, their non-competes are essentially banned except for those making it above a certain threshold, these highly compensated workers. And this is determined by the Colorado Division of Labor Standards and Statistics. So for 2024, that threshold amount is a little over 123,000. And I also want to note that Colorado also has similar provision for non-solicit agreements. So this threshold is about 74,000 in 2024. Illinois, for any of our clients in Illinois, the Illinois Freedom to Work Act prohibits non-competes for employees unless they have actual or anticipated earnings that exceed 75,000. Additionally, Illinois has that restriction on non-solicits as well, and that's a threshold of 45,000. Other states that we're seeing having this is Maine, Maryland, Massachusetts, a lot of the East Coast. We also have Nevada, Oregon, as well as Washington, D.C. And so we've talked a bit about the restrictions for these non-competes, but I want to look at, I'm going to move it over to Randy to look at what helps create an enforceable non-compete. What are those restrictions?
Thank you. So let's look at the scope. And I'll just back up a second here and explain, what the courts look at this stuff, what you'll see under the law is most of the states will say generally restrictive covenants are unenforceable unless they're reasonable, unless they serve a legitimate business interest or what we call a protectable interest for the employer. So you start out kind of with the presumption that they're not enforceable, but in limited circumstances, the court will enforce it. So we're always focusing on, okay, what is an enforceable non-compete? What can we look at? What are the courts going to be looking at? And put you in the best position either to defend these or prosecute these non-competes when you have them in your businesses. So there's a lot of way to carve these up. What I said at the beginning of this is a non-compete is that you don't compete. Well, what is compete mean? That can mean a lot of different things, the way you slice that up. So we're just going to talk about a few of those, the way they do it. Limited to geographic regions or scope. And there's a few ways to do that as well. So in an increasingly electronic and connected world and global world, we realize geography is less relevant, but it's still relevant today. And for some of you, maybe less relevant in your businesses, but for many of you, it's still relevant. You know, for example, in a sales rep case where they're given an assigned geographic territory, it may be difficult to get a non-compete beyond the region that they served or beyond the extent of the customers that they serve. So most courts don't necessarily require it, a geographic restriction, if it serves the legitimate interest or the protectable interest of the employer. However, there are some where it can't substitute. So I would say the general rule is, for example, a customer restriction might be able to substitute for a geographic restriction, and it wouldn't necessarily make a non-compete unenforceable because it didn't have a geographic restriction. But places like Louisiana, if you've been to Louisiana, it's a great time, but it's a different world. And they have parishes in Louisiana. And by statutory law in Louisiana, you have to specify the geographic coverage, and there has to be a geographic coverage there, and it has to be by parish in the state of Louisiana. So it's an interesting one where you have to have that. Now let's talk about duration on these too. We've got in there limited duration. I get asked this all the time with a particular matter where when we're drafting a non-compete for somebody is, well, how long can I enforce this non-compete for? What's the longest I can get? And there are goalposts out there, and there are general guidelines in most states where you will see that typically, for example, 1 year is enforceable. And that might be by statutory law, there's a presumption, or it might be by common law where the courts say, yeah, we're going to presume that. And then you can get more, potentially, maybe 2 years, depending on the circumstances. And so that can vary. And of course, that can go between, what the position is, what's the protectable interest in there. For example, in Utah, it's a 1 year from termination, and and that's it. In Massachusetts, it's 1 year unless the employee engaged in some bad act or conduct. And those, again, are a few exceptions, but those kind of demonstrate the rule. But I always look at it from this standpoint. I always want to analyze it from, let's start with what we think a court is likely to enforce. But then ultimately the question is, what amount of time is necessary to protect the protectable interests or the legitimate business interests? So for example, you may have a customer relationship issue, and I would say the focus should be on, well, how long is it going to take to replace that salesperson and protect that information, or protect that relationship, I should say. In the case of confidential information, we may ask, well, how long is that information confidential for? When does it go stale? How long could it create unfair competition and really cause damage to it? And if we can establish it's above or below kind of that presumptive threshold, that's what we want to look at for those. And some additional points here in terms of other ways that we want to carve this down. So a non-compete, again, can mean that somebody is prohibited from working in any capacity for a competitor. And a lot of non-competes are written that way. And a lot of times the courts won't go that far. There's the old cliche joke, okay, so this executive couldn't go be a janitor for a competitor. That means the non-compete's overly broad. Most courts don't look at it that way. Some courts will look at it that way, which is why, when we can focus and narrow this down, we do. So we may say, you can go work for a competitor but you can't work in a division or the area of business that's competitive with what you were doing for your current employer or for us in that sense. Or you may say, you can go work with certain customers, but you can't go work with the ones you worked with or about which you have confidential information about. So again, it's limiting and focusing the non-compete, in which case it's going to be more enforceable, and again, provided it's protecting the interests that you want. And as we note there on the slide there, it may be the same or similar position on there too. So a lot of times we'll write it to say, you can't work in the same capacity that you worked for us. So that it's a little vague, but I think it captures the idea of saying, if you're in a certain executive position, we don't want you going in an executive role for a competitor because you might be involved in strategic decisions or have information that can be used across the scope of the organization. But if you want to go work in a lower level position or something completely divested from the business you're in, that would be okay in that sense. And again, what I would say is, these need to be used in the scope of the other tools that we're having here, and we'll talk a little bit about that. So these are to work in hand. So for example, in trade secret protection, these are not mutually exclusive. So when we talk about these areas, we said there's statutory and state trade secret protection. Those aren't mutually exclusive from a non-compete. Just because you have those, it doesn't mean you shouldn't have a non-compete. And just because you have a non-compete doesn't mean you can't have those interests as well.
So Randy's discussed how to make a non-compete reasonable, but what happens when you go into litigation and the courts look at, well, these provisions are overbroad. So courts do have the ability in some states to modify or blue pencil overbroad non-competes. So there are kind of three strains of thought with that. So some will modify, some will strike, and some will not modify at all. So in some states, when a court finds that a restriction is in a non-compete agreement or is unenforceable because the provision's overbroad, the court may modify the agreement to narrow the covenant so that it becomes enforceable. This is blue penciling. So strictly defined is when the court strikes out certain information or certain words in the agreement. Other states, there's a more lenient theory where courts will modify the language. And so they will actually rewrite some language. And so some of these courts will follow this reasonable alteration approach where courts have this discretion to modify the terms. In other states, the courts do not permit blue penciling and will not modify the agreement. There is some movement where courts who previously would have modified or blue penciled have refused to do so, again, even if they had done so in previous cases. This is part of a greater trend towards restricting non-compete agreements and provisions. One huge example is the state of Delaware. In 3 recent cases, this trio of cases from 2023, the Delaware courts refused to modify an overbroad non-compete provision to make it enforceable, therefore holding the non-compete was not enforceable. In one of the cases, the court opined that revising the non-compete to save the employer, the sophisticated party, from its overreach would be inequitable. A court should not save a facially invalid provision by rewriting it or enforcing only what the court deems reasonable. So we can expect that there's going to be this continuing trend for courts to possibly refuse to modify or modify less of the agreements. But again, taking a big takeaway of this is not to just create overbroad provisions and expect that the court will modify it. We want to make sure, as Randy discussed, to make sure that our provisions are what needs to be protected for your protectable interests, but not as overbroad, but really focus on those specific areas, geographic scope, temporal scope, and positions. And with that, there are other ways to protect your business interests as well. And so that we've kind of talked about it with non-solicit agreements. This can be with customers or employees. So with customers, an example would be prohibiting a former worker from soliciting customers that they worked with the past 24 months. They can also be prohibited from soliciting employees to come to their new employer. And there's also non-disclosure agreements and confidentiality clauses to protect that those protectable business interests, any confidential information, and trade secrets. Again, this is one way to make your provisions and restrictive covenants enforceable and more limited. Now we've talked about the trends of non-competes and what states are looking at, but let's see what's next. Randy's discussed how the FTC rule is no longer in place, but we just want to go back a little bit. If you were on a pirate ship in the Caribbean, maybe you didn't hear about this. I know my good buddies on the pirate ships didn't. So just to give you a little background, on April 23rd, 2024, the FTC voted 3-2 to issue a final rule that would ban virtually all non-compete agreements for nearly all workers. And this was scheduled to come in to become a rule effective September 4th, 2024. In the final rule, the commission had determined that was unfair method of competition and therefore a violation of Section 5 of the FTC Act for employers to enter into non-competes with workers and to enforce certain non-competes.
Yeah, so what does that mean now? You know, we were all kind of, I won't say scrambling, but, you know, I had conversations with a lot of you, and I know others did as well, as to getting ready for that. What do? We were going to have to send notices out that, you know, I think crazy provision that the FTC said, not only are we going to ban them, but you have to tell employees that basically all existing non-competes are void and unlawful. Well, we didn't necessarily agree with that, and we didn't know if that was going to be the law on that. So we struggled with what we were going to do with that. Well, you know, that thankfully is put on hold now, and we can do that. I expect most of you didn't send those notices out. I think the ruling came, thankfully, at least, you know, under the wire sufficiently, where probably a lot of you didn't send notices out. If you did, I would revisit that. I'm not necessarily suggesting that we want to send another notice out, but depending what your notices may have said, maybe just sending another notice out, just reiterating to employees, if you did, that, hey, the FTC rule has been put on hold, and we do consider anybody that's under restrictive covenant for those to still be in effect on that. We don't know if the FTC is going to appeal that or not, so we're not quite sure what the situation is going to be. So it's a little bit of wait and hold on that, but I don't think anything is going to be changing, you know, immediately on that regard.
Yes, and just to follow up, in that litigation, the court prevented the FTC from enforcing the rule nationwide, not just against Ryan LLC. So, and so just because with that litigation, we also are seeing more efforts to restrict non-competes and other restrictive covenants. So the FTC and the Department of Labor have signaled that more non-compete enforcement actions may be on the horizon, not just that previous rule and ban. On August 30th, 2023, the FTC and the DOL signed a memorandum of understanding that set out coordination in investigations and sharing of information between the DOL and the FTC related to labor and competition issues. The General Counsel of the Department of Labor issued a memo noting that non-compete agreements interfere with employees' exercise of rights under the National Labor Relations Act. The General Counsel, she said, non-compete provisions are overbroad. That is, they reasonably tend to chill employees in the exercise of their Section 7 rights. Non-competes violate labor law unless the provision is narrowly tailored to special circumstances justifying the infringement on employee rights, pardon me. So we're going to see the Department of Labor, it's going to continue this trend towards narrowing and trying to restrict non-competes. We're also, depending on how November happens with the White House administration, there might be changes with how the FTC and the Department of Labor continue this trend towards restriction of non-competes and restrictive covenants. And then we're going to anticipate seeing more changes at the state level. There are dozens of new proposed legislation Just a few examples are in New York, they proposed a non-compete ban for virtually all non-competes. However, the governor vetoed that bill and called for a carve-out for the higher wage workers, similar to Colorado. And then, as I noted before, California further strengthened its ban and expanded non-competes against contracts signed outside of the state, as well as providing for that private right of action.
Okay, so where does that leave us? I mean, it's interesting. It reminds me of like paid sick leave laws that are just every day there's a new paid sick leave coming on. And I think in recent years, the non-competes have had kind of a similar fate, but we haven't succumbed to the nuclear option, at least yet, on that. So for those who believe there's a good place for those non-competes, at least we're still in the ring fighting on this. So what should we do now? I think it's a good opportunity to kind of take a step back now. And probably a lot of you were doing this when we were looking at the FTC ban potentially going into effect is well, what should we be doing now? Well, I think one thing is to take inventory. I know I talked to some clients who were having difficulty even understanding what non-competes they had, what restrictive covenants they had, who had them, were they still in effect, could they find documentation of them? No surprise, particularly for large employers and for some of these agreements that may have been in the file for years. But it's a good time to take stock of those and take a look at them and say, what do we have? Do we feel that they're enforceable? Do we think that they're appropriate? Can we tighten them up? Maybe should we consider modifying them in some way, or saying, hey, maybe ours is a little bit more overbroad, and maybe we can tighten those up. But I think this is just a good opportunity to take stock and take a look at that.
Another is to consider other options for protecting your confidential information and your business interest. As I previously noted, those can be your non-solicits, also your non-disclosure agreements around who has, and then also strict controls around who has access to your confidential information. So analyzing whether confidential information meets trade secret status, and if not, what to do when that confidential information is in that framework. So even without non-compete agreements, you still have some trade secret protections, as Randy noted. So your trade secrets won't be impacted without a non-compete, but making sure that you consider all options for protecting your interests.
And just to bootstrap on that, then on those trade secrets, it's a good time to make sure we're maintaining them as trade secrets. When we get into litigation, whether it be trade secret litigation or non-compete litigation, where we're trying to enforce the non-compete based on trade secret protection, I mean, we get into a real battle, and we get really down to the nitty-gritty in terms of what steps have you taken to maintain the information's confidentiality. How valuable is it? What are you doing to protect it? Is it limiting the access to that information? Is it limiting it by password protection, and who can use that information? Is that information still relevant? Is it stale or not? But we go through a whole checklist on that to make sure it's trade secret. And a lot of times we get in conversations and we start with, well, we know that's a trade secret, but have you demonstrated it through your practices?
And then lastly, we've talked all about this with protecting your interests for employees leaving, but you also have to have the same considerations applying when you're hiring employees as well. So did the employee have agreements with their former employer? What are they bringing in? You need to make sure that they're not bringing in all that information. If they are and they have these non-competes, you might be up against a lawsuit for tortious interference. So these are all really good considerations that we've talked about. It's going to be likely changing again, so stay tuned. But Randy and I have to go hop on a pirate ship, I think, and we're going to throw it back over to AJ.
Thank you very much. Appreciate that, Ely and Randy. And as we move into our longer break of the afternoon, if you need to step away, we're going to take about 10 minutes or so before we get to the next substantive presentation. So certainly use this as an opportunity to take a break, get some steps in. But if you are interested, you can certainly stick around, because we will have some content during the break that I'll present to you. And that content is what I'm calling the annual illegal update. So you've been hearing a lot of legal update information so far, ways to comply with the law, risk around certain activities, changes. Here, we're going to give you an update about, well, illegal conduct. Hopefully not something that any of you were personally involved in, but I can't know that for certain because there are many of you logged in. But here's how we're going to do it. It's going to take the form of something that I'm calling, and I just came up with this off the top of my head, 2 lies and a truth. So for the most part today, we have been telling you things that were, true. However, we're going to, in this presentation, I'm going to tell you 2 things that are not true. And your job as the audience is to hear all 3 stories about employees who engaged in some illegal activity or were affected by it. And then you're going to decide which of them is the true story about an employment-related illegal activity. So without further ado, we'll jump into that first story. We're calling this story Embezzlement by Any Other Name. So I don't know her personally, but Sheila Strauss seems like the sort of person who would be a real believer in that strange old idiom, what's good for the goose is good for the gander. Now, I looked it up online, and Webster's Online Dictionary confirms that what that means is that what's good for one person, in this case the goose, is also good for another person, in this case the gander. As an aside, a gander is a male goose, also searched out, and it's the basis of that phrase, let's take a gander at something. It means, a goose that can sort of bend its neck to look at something sideways or differently is taking a gander, a male goose. In case you weren't so sure about the etymology of that particular phrase, you now know it. But anyway, let's put that aside, and let's get back to taking a gander at what Ms. Strauss did. So Ms. Strauss worked in quality assurance at Central Milling's grain mill in Logan, Utah. And at that mill, they would turn whole grains into organic and artisan, I guess is the better word, flour for bakers. And shortly after Ms. Strauss started, Central Millings launched a new product. It was a countertop home grain mill where you could take whole grains and grind them into fresh flour right there in your kitchen. It's the dream of many bakers. And of course, Central Milling was excited about this product, and so they actually allowed any of their employees who wanted to take one of the mills home. The problem is that our hero, Ms. Strauss, does not bake. So she realized that a fresh homemade flour mill was not worth anything to her, but it was worth something to her coworkers. In fact, they cost $350. So she decided, if my baking coworkers, in this case the geese, get something that's worth $350, then I should get something that's worth $350 as well as the gander. So she took $350 worth of cash from the company's petty drawer. And when she was caught and fired, she challenged her termination, claiming discrimination, because surely there was no legitimate reason for terminating her for engaging in the exact same conduct that her employees had engaged in. Of course, that was simply taking something worth $350 from their employer. Thankfully, I think for all of us, the court disagreed, dismissed the case against Central Milling, and confirmed that embezzlement is never good for the gander. Our second story is called The Hitman Cometh and Work Comp Payeth. Something I think that's lost in this modern age where everyone has a cell phone that has a specific number for that person is the thrill that we used to get cold calling somebody's landline, not knowing who was going to answer on the other side. If you are my age or older, you know the genuine panic you would feel when calling the home of maybe a middle school friend or crush and having one of their parents answer, ask who you were and what exactly your intentions were with their daughter. Of course, landlines still exist for some people, and they can still wreak havoc. Just ask Arthur Mosley, a store manager for Hannaford Brothers, which is a regional grocery chain in New York and New England. Presumably, they sell decent bagels. One fateful day, Mr. Mosley received an email directing him to call his employees and change their schedules for the week in order to save some money on labor costs. So he worked down his list and eventually called the home phone line of one Mrs. Heidorf. But Mr. Heidorf answered the call, and Mr. Heidorf was suspicious about why his wife's male manager, was calling her at home. So he jumped to the natural conclusion his wife was having an affair with her boss. And this was not something that Mr. Heidorf was going to take sitting down. So he stood up and started a weeks-long harassment campaign against Mr. Mosley, calling him and following him around at work, making anonymous complaints that caused his employer to investigate whether Mr. Mosley was in fact engaged in inappropriate conduct or relationship with a subordinate. And although he was eventually cleared of any wrongdoing, all of the stress of it caused Mr. Mosley to request a transfer to a different store. But that's not where it stopped. And that's instead what led to the next fateful phone call, which was when the police called Mr. Mosley and let him know that Mr. Heidorf had just been arrested after he had attempted to hire an undercover cop who was posing as a hitman. And Mr. Heidorf's plan was to pay this man money to murder Mr. Mosley. This news triggered Mr. Mosley's pre-existing PTSD, causing him to experience severe symptoms that prevented him from working. So Mr. Mosley filed a workers' comp claim, alleging that the PTSD complications were caused by, or were a work-related injury. The grocery store disagreed, saying this was based on a personal grievance between the spouse, the potentially, although not actually jilted spouse of a coworker. But over the employer's objection, the New York Court of Appeals Appellate Division agreed with Mr. Mosley, finding that the only connection between Mr. Mosley and Mrs. Heidorf was their employment, and therefore that employment was also the nexus of the conduct by Mr. Heidorf, and the claim paid out. And finally, story 3, a real fraudy cat. True creativity in management is a rare thing. It's wondrous when it happens, that spark of inspiration that causes some mid-level supervisor to identify a path towards corporate success that has never been trod before. And Michael Raley had just that kind of spark. Coming out of the pandemic, Mr. Raley found himself supervising a large number of at-home call center employees for his employer, Gold Star Staffing. But he had a problem. Since they moved at home during the pandemic, his employees stopped using PTO. And because Gold Star Staffing has a rollover PTO policy, his employees had a significant PTO liability on the books, and this was affecting his numbers and put his bonus in jeopardy. Then on the news, he saw a story. It was about a local teacher who got sick. Though fellow teachers donated time, they donated food, they helped with their kids, and relevant to this story, they donated their vacation days to let the teacher be out on paid leave longer than she otherwise would have been. And the light bulb above Mr. Raley's head turned on. If Mr. Raley could get his employees to donate their PTO to a team member in need, he could run down the balance and he could earn his bonus. You may think he's about to poison someone, and he doesn't. Instead, taking advantage of the fact that his remote workers rarely saw each other in person, he invented one. Her name was Evelyn Johnson. She had social media profiles that he created. She had a work number. She had an employee ID. She had a work email that she sent introducing herself to her colleagues. And then wouldn't you know it, a few weeks later, her cat got terribly sick. Miss Johnson's beloved family cat needed surgery. It was far away and it was going to require significant travel and time out of the office. But because Miss Johnson was so new, she didn't have any leave available. Still a little unclear why he chose a cat instead of a person. Maybe it felt a little less icky to create a sick cat rather than a sick person. But no matter what, it worked. Many of her colleagues donated from their PTO balances to allow her to take the time off that she needed, brought his numbers down to where they needed to be. And as far as he was concerned, everything was going well, right up until the scheme unraveled when a colleague, one of the cat's benefactors, requested a tax form so that they could use the PTO or the balance of their PTO as a tax write-off. The company investigated. Mr. Raley was fired. And according to the lawsuit that's pending against Gold Star Staffing, those employees were made whole, but not completely whole for his misdeeds. Unfortunately, or fortunately for this story, we more or less got to the place where it needed to be. But I think as a result of Mr. Raley's actions, there is a little less trust in the world. So now it's your chance in this poll question to say which of these is the true story of an employee who engaged in and even tried to benefit or was affected by illegal activity. Is it embezzlement by any other name? Is it the hitman cometh and work comp payeth? And is it a real fraudy cat? So take some time to hit answers on this poll. It will not affect whether you get any credit for any of the presentations here, but I am curious to see if anybody has an idea as to which of these is the true story. And I assume that at least some delay is by those members of our audience who cannot help but try to Google these 3 stories to see if they can find the answer. All right, we'll give everyone a few more moments to get their answers locked in. And we'll take a look. So our audience thinks 24% think it's the first story, 35% a real fraudy cat, and 40% believe it's the story of the hitman. And those 40%, a plurality of our wonderful audience, are in fact correct. So everyone who got it correct, if you think to, you can certainly drop a comment in, and you are entitled to one congratulatory remark from any of our presenters today, either the next time you see them in person or they'll send it by email. So just let us know. And please do be honest. So now we're going to move to the next substantive presentation. And that is our immigration presentation from our two wonderful immigration attorneys. The first, Kelly Mylink from Kansas City. The second, Tiffany Baldwin from St. Louis. As with the others, I'm going to give a little bit of information about them. Kelly, who currently lives and works in the Kansas City area, is from the exotic and distant land of the Wichita area. And she actually grew up in a suburb of Wichita. For those of you, it might be news today to find out that Wichita has suburbs, and it does. And the suburb specifically that she is from is called Derby, Kansas. And when you look up Derby, Kansas, and you go to the website TripAdvisor, and you look up what are the things to do in Derby, Kansas, your attention is drawn to an activity that I can only imagine Kelly has participated in, if not in person, in her dreams many times, and that is playing miniature golf with dinosaurs. Because in Derby, there is a dinosaur park that includes miniature golf among the dinosaurs. That's Kelly very much enjoying her miniature golf. If you're not sure, this is what it actually looks like. So not too far off AI. Kelly's not, to my knowledge, in this picture, unless she's both well hidden and subtly included. Of course, it's not just Kelly. By the way, this park, this dinosaur park, is the #1 rated museum in all of Derby. One of one in all of Derby, Kansas. But Tiffany's going to join her. Tiffany is from the St. Louis area. And Tiffany is something that's kind of rare on this side of the Atlantic Ocean. She's a football hooligan. So we're using football in this sense to mean what we in America typically call soccer. And Tiffany has developed a passion for the local club here in St. Louis called St. Louis City. That's her screaming among a whole bunch of other people also screaming. Here's a real photo of Tiffany and her family enjoying a match. She is at that point, I think, about to become a soccer hooligan, but hadn't yet. So with that, we will send it to our other studio, and you will get to hear the immigration presentation from Tiffany and Kelly. Thanks.
Thank you so much, AJ. Thank you for that introduction. No, I'm Kelly Mylink. I am here with Tiffany Baldwin, and very delighted to be presenting, I think, for the first time.
I know, yes.
Yes. Tiffany joined our firm about 1.5 years ago. She has had an extensive career already in immigration law, so if you have not spoken with Tiffany or met with her before, she is a wonderful addition to our group, and I'm excited you get to hear from her today. Today we're talking, we're immigration attorneys, and we're not going to talk about visas. We're actually going to talk about Form I-9 and E-Verify. For those of you who don't know, the Immigration and Nationality Act actually encompasses the Form I-9 rules, which also sort of govern E-Verify as well. And most of what's been happening in the immigration space this last year really has to do with Form I-9 compliance, E-Verify, and those immigration agencies that enforce those rules. So anywhere from, we have the Department of Labor involved, we have the Department of Justice involved, we also have the Department of Homeland Security, also heavily involved in enforcement of these two programs. So we're going to talk a little bit about 2024 trends and highlights. And we've got several topics to get through today. We're going to talk a little bit about SpaceX. SpaceX had some recent fines for immigration-related violations that are really instructive for employers. So Tiffany's going to talk to us a little bit about that. We're going to talk about E-Verify participation and remote verification of Form I-9. We're going to talk about enforcement of the remote documentation verification program and the enforcement by the Department of Justice's Immigrant and Employee Rights section. We'll talk a little bit about this new thing called E-Verify Plus, which is this interesting new program put out by U.S. Citizenship and Immigration Services that combines Form I-9 and E-Verify. And then finally, we're going to talk about Form I-9 audits, your favorite, and just a little bit about what's happening in that world and what Homeland Security investigations is sort of doing in their focus for the past year, and what maybe their focus will be with the next administration in power. With that, Tiffany, why don't you talk to us about SpaceX?
Great. Hi, good afternoon, everyone. So we see quite a bit of news about citizenship and national origin discrimination. And most recently, we've seen that with SpaceX. So what has happened is that the Department of Justice, has alleged that SpaceX discriminated against asylees and refugees in its hiring process, mainly in its ads and recruitment process, in violation of the law. And mainly, SpaceX has limited its job ads for a certain period of time to only U.S. citizens and U.S. permanent residents, saying that, hey, we have all these export control regulations, ITAR and EAR, and so we have to screen these applicants. And the Department of Justice correctly says is that, well, the ITAR and EAR are, they're not broad bans. They're not broad exclusions on hiring. What they are is you have to get a license or a license exception if someone isn't a U.S. worker. And so by limiting their job ads to only U.S. citizens and U.S. permanent residents, they were discriminating against other U.S. workers, including asylees and refugees. In addition, their ads were very broad. So even for welders or baristas working at SpaceX, they still had the U.S. citizen and U.S. permanent resident restrictions. And this is not uncommon. SpaceX is probably the most recent big company to run into that, but in the past, shortly before the Department of Justice made its complaint against SpaceX, it settled with General Motors for, I want to say, more than $300,000 for the same reason. They were discriminating against U.S. workers that were in asylees and refugees because using ITAR and EAR as an excuse. And again, any sort of discrimination in the recruiting and hiring process based on citizenship and immigration status has some potential consequences, including back pay and civil penalties. Again, General Motors, that's quite a big civil penalty. And also included in that settlement, for instance, is often training, changing policies, and the like. So it is, again, the financial consequences and also a bit burdensome in having change in processes and procedures. So we like to remind employers to, be mindful, be very demure in their recruiting and hiring process. So you need to understand that which jobs would be restricted based on government contracts or other sort of requirements to U.S. citizens or permanent residents. Sometimes it's confidentiality or security reasons. Some that might have the export control, which is, again, after hiring, might have those considerations, and to construct their job ads in return. So don't have restrictive statements in the job ads. Certainly, if there are considerations like ITAR or other types of export control, you can mention that that job may have those to kind of as a heads up, but again, not restricting them that early on in the recruitment process. And when it comes to onboarding, the I-9 process, we'll talk about a little bit more, not to ask for employees, especially non-U.S. citizens, for more or different documents. So again, it is always the worker's choice of what documents they present for the I-9 process. You don't get to decide. And if they present a document that looks bona fide, that you need to accept it. So asking for other documents also can ding employers. And in addition, we have seen a lot of regulatory changes and guidance on how long there are employment authorizations. So sometimes people can renew their employment authorization, and while it's pending, their employment authorization is extended. So even if the document they present has been expired, that's not the end of the story sometimes, and you have to look further because there may be a pending application that allows them to extend their work authorization. So again, it is to make the recruiting and the hiring and onboarding process comply with the law, and make sure that you aren't discriminating against those just based on their immigration status.
Before I move to the next slide, I just want to add to that, because a lot of these things that Tiffany was just talking about are things that you are over helpful HR, right? You can get in trouble in the I-9 space by over-reading the export control laws and thinking that you need to exclude certain statuses because you're reading into that, and you think that if they're an asylee or a refugee, oh, I can only hire US citizens and US permanent residents. Or in the I-9 context, we often encounter situations where employers are an HR professional is saying, oh, no, actually, if you just present me this and this document, then we can fill out your I-9. And that can also get you in trouble when you're trying to be helpful, but at the same time, getting yourself in trouble with those I-9 rules because you have then told the employee what documents to provide rather than giving them the choice of documents to provide. So SpaceX, this is a lawsuit that actually continues. SpaceX is now suing the federal government, saying that you don't have power to impose these penalties to begin with. So that's kind of an interesting saga to watch. But it's very easy to see how employers can be investigated by the Department of Justice by an unknowing circumstance. So these are things that we watch and always want to give helpful reminders to employers. Turning now to E-Verify. E-Verify participation has, of course, increased as employers have wanted to take advantage of the remote verification program that came into effect last year. So last year, the U.S. Citizenship and Immigration Services finally said, okay, employers, we give in. You can verify documentation in the I-9 process remotely rather than the employee having to come to you, providing you those physical documents in person. We will allow for remote verification. But they put some parameters on that, right? They said, hey, okay, we'll let you do this, but it has to be by live video. We can't have them scan the documents to you and not actually meet with them face to face. So you have to have the live video, you have to have them hold the documentation up to the camera, and you also have to get those scanned copies front and back to keep with the form. And you also need to be enrolled in E-Verify. So the one important key here is enrolled and actively participate in E-Verify. So you can't just sign up for E-Verify and say, okay, now we can use remote verification. You have to be using E-Verify and complying with those program rules. The one thing about the new Form I-9, and it may be different if you're using an HR service to complete Form I-9, but there is a box that you check on the Form I-9 if you use remote verification. So if you are engaging in this program, you want to use these rules, you need to make sure that box is checked on Form I-9 just to say that you did, in fact, are using the remote verification program. The last note here is that you want to retain copies of all documentation presented with the Form I-9. And what we mean is the documentation's required for Form I-9. So if the employee comes to you, they hand you everything in their wallet, don't make copies of all of that. You want to hand it back to the employee, have the employee choose which documentation they would like to include with their I-9. And those are the copies of documents you need to include, not everything that they pull out of their wallet. So it's an interesting program. Of course, it's going to increase participation in E-Verify. And But you have to be careful that you're following those rules and following the E-Verify rules.
Yeah, I wanted to jump in on that is that, yes, as Kelly mentioned, there is that box to check that you're doing remote. Whether you're doing in person or remote, if that box isn't on the form, you're most likely using the wrong form. And when I've looked at I-9s and kind of doing an audit, I'm sure Kelly has too, one of the most common kind of errors is that they're using the wrong form. And so really make sure that you're using the August 1st, 2023 form going forward. And if it doesn't have that box for remote verification, you know you're using the wrong one. And so because we're doing so much more, there's such an increase, I want to say maybe 25% increase in E-Verify since the remote I-9 verification has come into play. We are seeing the government saying, hey, we're going to review I-9s a little bit more. We're going to be doing some more enforcement efforts. So they announced that. And if we see a change in the administration come January, we may see even more of that. So that is very important to keep in mind. In the past, some enforcement efforts have focused on certain industries, but here I think it may be more widespread, especially with those that are doing remote verification. In addition, because of the increased inspections, it is so important to make sure everything is done very, very correctly, because in June, at the end of June, the fines increased. And so for, the I-9, it looks deceptively simple, but there's so many ways to get it wrong, even if it's, missing a date or missing a checkbox or some blank. And so each I-9 paperwork violation, now it can range from a little under $300 to a little under $3,000 per I-9. So it's not chump change here. For knowingly employing an unauthorized person, those have also increased to, again, a little under $700 if it's a minor first offense to, I want to say almost $28,000 if it's, this is your third or fourth or fifth offense and it's widespread. And then same way with document abuse. So where we talked about, the types of documents that are submitted or asking for more or asking for different documents, those types of violations also add up from a little over 200 to a little over 2,000 per violation. So it's really important to keep that in mind. And so in addition to making sure that the forms are correct, the administration of your I-9s and how you do them, whether it's remote or in person, consistency is key. You don't want to have one method for non-citizens and another method for citizens. You want to keep everything consistent. You certainly can opt out of the remote. As Kelly explained, you have to hold up the papers, and it can get kind of cumbersome where it may be easier just to do it the old-fashioned way. But again, if you're consistent about it, whether you're doing it remotely or you're doing it in person, that is the key. Again, the most common cases where there are violations are those documents abuse. Telling them, trying to be helpful and telling them what documents. And I have real life, just my high schooler, going to orientation for a new job, saying, in writing, please bring your passport for the I-9. And, that's a really great thing for immigration attorney child to show. So they're trying to be helpful, and I get that, but don't be helpful. They have a list, the A, B, C list, and go with that. Let's see. Don't ask. Really, again, in addition to the consistency, the I-9, because of the fines involved, because of the possible ramifications, it can't be treated like a simple clerical task. It is a very important administrative function, and compliance is key to making sure you stay on the right side.
All right. Well, with I-9s come E-Verify. E-Verify Plus is something completely new that you may not have heard of yet. E-Verify Plus is a program that U.S. Citizenship and Immigration Services came out with just last year, which the intention of, and I'm going to, this is exactly from USCIS's website, streamline employment eligibility verification by combining Form I-9 and E-Verify into one seamless digital process. So in theory, it's a program that allows you to complete Form I-9 and E-Verify through your E-Verify account all in one. It's mobile friendly, tablet friendly, desktop friendly, everything, right? It's supposed to make it easier for employers and employees. The program itself was introduced to some employers, not all yet. If you are an employer who did get solicited to test out this program, will you let me know? Because I'm very interested in your feedback, because what we understand is very few employers have engaged with the system and the feedback hasn't been great. The problem is the same as it has been with a lot of immigration rules and new technology, right? Our immigration laws are so old. They're decades old. And technology is, the regulations have not really evolved with technology. So now we have this really good program in theory, but doesn't necessarily tell us how to comply with the particular rules regarding electronic storage or electronic completion of Form I-9. It doesn't really, if there, Section 1 needs to be corrected in some way, the program really doesn't tell you or allow you to do that as the employer. And particularly because the way that the program is intended to work is once the employee includes and fills out all of this information, it carries with them to their next job. So you don't actually fill out a new form when the employee, if they've already completed it, when they change jobs, which isn't necessarily friendly for employers if you aren't going through the process with them. So there's a lot of still some gaps in this program about how it will be implemented, how it's going to comply with the regulations. Right now, there are a lot of benefits to employees, right? Not having to fill out the form every single time when you change jobs, but it doesn't necessarily benefit employers. So it's still in sort of a testing phase. We're hopeful to hear more information about it soon, but as of right now, it is still sort of in that testing phase. We'll see sort of a new iteration in how that works. A lot of you probably have HR software that already integrates Form I-9 and E-Verify. This program is different. So HR software, sometimes you fill out Form I-9 and it just goes straight into E-Verify. This is a different type of program. It's completely free. It's all through your E-Verify account. And we're just kind of monitoring it now and see how they change it in the future. But it is something to keep on your radar. It is something to watch, because I think there is a big push for this program in the future because, one, we get more employers participating in E-Verify, and that's one of the goals. But two, we want to make it easier, and we want less mistakes on forms by employers and by employees. Additionally, we want to close out today by talking a little bit about Form I-9 audits, right? One of those things that is the result and what you're afraid of when you make a mistake on Form I-9s is there's going to be some sort of audit. For those of you who don't complete a Form I-9, the Form I-9 itself, when you complete the form, as the employer, you don't send it to the government, you just keep it on file, and there's retention requirements related to keeping the Form I-9. Eventually, and maybe never, the Homeland Security Investigations, or HSI, might come and audit you. And they might say, hey, we need to see all of your I-9s between this particular time period or for all of your employees. And they will review all of your I-9s and issue either usually sort of notices of deficiencies. Here are all your technical violations. Here are all your employees who may be unauthorized to work. And here are all your employees who are definitely unauthorized to work and who you should terminate. I-9 audits by Homeland Security investigations usually are around 5,000 to 6,000 a year. That's pretty average. We have seen a decrease in that number in 2024. We know that there was sort of a call for more investigators, so they were trying to hire more people. So we're not sure why that number is low. I think if you remember, if you were doing this during 2018 and you were filling out I-9s, there was a period of about a week when Homeland Security investigations issued about 2,000 audit notices in the matter of just a couple of weeks. So maybe that's coming. I don't think it is. But right now, it could be that Homeland Security investigations are focused on other priorities as well. So I-9 audits are still around. They are just a little bit slower this year than they have been in the past. And generally, I-9 audits have been taking a long time. So companies that do get audited will hand over their documents, and then it could be 2 years before they hear any results of that audit. Homeland Security investigations does target specific industries. That's always kind of been the case. But the majority of audits do come from employee complaints. And that's still true. So an employee who thinks that they've been discriminated against in the I-9 process, or who maybe you were, that example of over-helpful HR telling them what to present, or you rejected documents that you shouldn't have rejected, and that employee complains either to the Department of Justice Immigrant and Employee Rights Section, they have a hotline, right, or Homeland Security investigations, then that could trigger one of these audits. Every different presidential administration uses the audit program in different ways. So as we saw during the Trump administration, we saw less audits, and we saw Homeland Security investigations using their investigatory power, workplace raids. Those were more prominent than the paper-based I-9 audits. The Obama administration was yearly utilizing the I-9 audit process rather than sort of the investigation, flashy raids type of enforcement. So it kind of remains to be seen. I mean, we can kind of predict where we could see HSI go with the different two candidates based on who wins the election. But the bottom line is, Homeland Security investigations is not going away. They are still going to continue to conduct I-9 audits and through their enforcement power through investigations and paper-based audits. There is the potential of the possibility of remote form I-9 verification, so using that program without having to enroll in E-Verify. There's been some rumors about that. I don't necessarily know if that's true, just because one of the priorities is to get more employers to utilize the E-Verify program. It kind of makes sense that they're going to be reluctant to implement the remote verification process for non-E-Verify users just yet. So we have a lot of things, a lot of changes on the horizon, obviously, with Form I-9s and the next administration and how they will use this enforcement power. But the bottom line is, you need to be filling out the I-9 correctly. If you're using the Form I-9 remote verification process, you need to be completing that process correctly, and just making sure you understand and know all of those rules of the Form I-9 process, particularly as things change. The Verify Plus program comes out, and we start seeing new changes in 2025.
And I would say that, you never know when there might be an audit. I mean, maybe never, but it may be. And the stress would be a lot less if you regularly audit your own, do some self-audits, especially if there's been a huge change in HR, or there's been a merger of companies, or there's been any significant change that the processes and procedures on onboarding folks has changed, where processes may have been less mindful, if you will. And just general, it's just great maintenance, just like you go to the doctor every year for an annual checkup. It's nice to kind of make sure that your best practices are being adhered to, and that your forms are correct, because again, those little errors add up. And that way, if you get an audit from the government and you've audited your forms within the last couple of years, you're probably going to be in good shape. in theory.
Well, we wish you all good luck with your Forms I-9 and your E-Verify practices. AJ, we'll send it back to you.
Thanks.
Kelly and Tiffany for that informative presentation and reminding us that our I-9 processes need to be very mindful. Probably helps to also have them be very demure. So as we go into our final, or second, I should say, to last topic, our penultimate presentation today is going to be about pay equity, and it's going to be brought to you by Barb Grandjean, an attorney who's joining us from our Denver office. Now, there are many, many things that can be said about Barb that might be of interest to you, but we'll try to keep it short so we can get to our next presentation and let her tell you all about pay equity. One thing, for example, is that where she lives, there are wood ducks that go whistling by her house. And she actually has constructed and put up a box, a wood duck box that is hopefully going to attract some wood ducks who will live with her and provide her some company in her autumn years. But that hasn't unfortunately happened yet. There's no wood duck nesting quite yet. Also, Barb, like many attorneys, is a lover of caffeinated warm beverages. Her preference, of course, like many, is coffee. Now, the challenge that we used to have in our Denver office is that we didn't have a coffee machine sort of worthy of the experience that Barb wanted and deserved. But that was changed when we switched our office location and we were outfitting the new office. Now, Barb is our office managing partner. So not only is she a coffee lover, but she is the Denver office managing partner. I mean, she is the lawyer in charge of the niceties of the Denver office. And so she used that influence as the move was happening to ensure that they were able to procure a new coffee machine, one that would make a variety of delicious, warm, caffeinated beverages, and one that apparently she frequents often. When I asked my colleagues for interesting facts about Barb, one of the first and then one that was repeated is that the coffee machine in the Denver office is named after a beloved Denver landmark. Well, specifically, it's named after Barbara Grandjean, because they've named the coffee maker Babs Grandjean, which I think is a wonderful sort of marketing concept and branding. I imagine the slogan would be something along the lines of like, why settle for a cup of average Joe when you could have some Grandjean? So Babs, being the nickname for Barbara, was a wonderful name. Now, what surprised me was not that the Denver office had selected such a wonderful name, but rather when I found out who it was that selected the name Babs Grandjean for the coffee maker, because my inside sources confirmed that that was in fact Barb Grandjean, who put her name on it and now has a progeny, something she can be proud of at least as long as a fancy coffee machine lasts, which probably isn't all that long. So the next time that you visit our Denver office, I hope that you will visit both Barb and Babs. Enjoy yourself a hot cup of coffee. And Barb is, in addition to a Starista, the head of one of the heads of our pay equity group here at Husch Blackwell. And she is an excellent source to talk about our next topic, which is, of course, pay equity. Thank you, Barb.
Thank you, AJ. And once this seminar is over, I'll be talking to you about what it means to fact check your sources before you make slanderous allegations on public TV. I am Barb Grandjean. We are going to talk about pay equity, and we are going to go the right direction and start with a poll question. Poll question 1, when was the last time your organization conducted a pay equity audit? Your choices are within the last 6 months, within the last year, within the last 2 years, or never. And I'll wait just a moment while you respond to this. And to let you know, I'm not going to tell you what the answers are. I'll tie it up at the end. And there's a big whiteboard sitting over here, so I think maybe that's where the answers will be when we get to the end. So we'll see. Give you just a couple more seconds to answer poll question number 1. And then poll question number 2. Where does the strategy for pay equity reside in your organization? Is it with the C-suite? Is it with HR? Is it handled by division or department? Or last choice, there's really no formal discussion of pay equity taking place in our workplace. Give you again a couple minutes, a couple seconds to answer this, and we'll do some benchmarking at the end, and you can see what your peers are doing. Let's give it just 5 more seconds. Okay. All right, so moving on, I'm going to start with some statistical information about pay equity. And then what I'm going to do is kind of categorize the different laws that we're seeing and the different levers that states and the federal government and local jurisdictions are using to try to drive pay equity. So here, the Pew Research Center in 2023 determined that in 1982, there was a 65% pay gap between men and women. By 2002, that had improved to 80%. And just 20 years later, it had improved to 82%. So I think that's notable, the slowdown in the last 20 years. As you might expect, the gender pay gap, according to this Pew research, is it increases for older women and it's more pronounced for women of color. April 5th, 2025 is National Equal Pay Day, and it's another way to look at the pay gap. So in 2025, on April 8th, a woman will have earned as much money as a man who worked through the year of 2024. So it takes a woman another 4 months and 8 days to earn as much as a man in a 1-year period of time. The EEOC has been publishing lots of infographics celebrating the 60th anniversary of the Equal Pay Act that was signed by President Kennedy on June 10th of 1963. So last year, 2023, the Federal Equal Pay Act turned 60 years old. And what I think is interesting is that by the EEOC's own infographic, over that 60-year period of time, there's been an approximately 25% improvement in the pay equity gap. And the EEOC, again, in its celebratory infographics, does not address the significant slowdown in the last 20 years that the Pew research identified. Also interesting, according to the EEOC, under the Equal Pay Act, there were approximately 480 equal pay charges in the last year, the past 5 years, excuse me, 480 Equal Pay Act charges filed by someone other than a woman, and 6,916 charges filed under Title VII for wage discrimination by someone other than a woman. So I think it's important to remember that although we talk about the gender and the ethnicity and race pay gaps, that it does go both ways. And then finally, the EEOC, again, in its celebratory infographics, talked about the amount of money that it's bringing in on pay discrimination claims. It's not a lot, relatively, $163.6 million. And we don't really have anything to compare it to. But at the end of the day, it is a pretty big number. And as some of our speakers have already identified, Jenna and Tim, the equal pay is something that the EEOC is strategically going to be focusing on over the next few years. So we'll see if these numbers improve by federal activity. So I believe that perhaps due to the slow pace of federal progress, that equal pay and pay transparency have really become something that the states and local jurisdictions are taking the lead on. And so this slide is really important, and the URL is in your materials, but the U.S. Department of Labor Women's Bureau has published this interactive map slide. And you can choose either equal pay or pay transparency with the radial buttons in the upper right-hand corner. And then you can hover above a particular state, and they've collected the different equal pay and pay transparency laws and regulations in each of the states. So as I continue to talk about pay transparency and equal pay through this presentation, I'm going to give you some examples of different types of provisions, but I'm not going to tell you exactly what each state says. I think that would probably be a waste of everyone's time. But I recommend this map as something that you would take a look at to get a closer idea of the different types of law that are out there. So when I look at the equal pay laws across the states and some local jurisdictions, I've identified what I believe to be 5 different levers that are being used to try to drive equal pay in this environment. And states and local jurisdictions are building some or all of these levers into their laws. And unfortunately, it's going to be different generally across the country. And we'll talk about that a little bit later, what it means to be a multi-state employer in this environment. But the 5 levers that I have identified are salary history limitations, pay transparency obligations, equal pay laws, pay reporting, and certification obligations. We're going to talk about each one of those in a little bit more detail. So starting with salary history limitations, by my count, which again is not perfect, I believe there are about 30 states and localities that have laws on the books right now related to salary history. So I believe this lever has been in place the longest. And the theory or the idea behind this lever is to break the cycle between past salary and current and future salary. So the theory is that employers should be paying for their jobs what the jobs are worth, and not just a little bit more than what the applicant used to make in an effort to try to save money. So the idea is that employers really need to scope out the position and the role and make a value judgment of what they are willing to pay for it. There are a number of variations to this lever that we see in the laws. One of those variations relates to timing. So in some states, like Delaware and Maine, it's okay to ask an applicant for their past salary, but you're only supposed to do it after the person has accepted an offer, and you're doing it simply to verify salary history. The laws also vary on the topic of the impact of voluntary disclosure on whether you can consider salary history in terms of hiring somebody or deciding how to pay somebody. And so in some states, like Connecticut and New Jersey and Maryland, if an applicant voluntarily discloses what they've made at a prior job, then that can be considered by the employer. There are some other states like Colorado and the local jurisdiction of San Francisco, where even if the applicant truly voluntarily discloses during an interview or the application process what they made at a prior job, these laws prohibit the employer from considering that at all in terms of deciding who to hire for the position or what to pay for the position. Interestingly, Mississippi is a law that allows employers not only to inquire about salary history, but to in fact use it as a defense to an equal pay claim. So as the law is written in Mississippi, if your employee believes that she has been unfairly paid as compared to a male colleague, Mississippi allows the employer to argue that that's because she didn't negotiate very well, and her prior salary coming into the role was less than his salary coming into the role, and therefore the unequal pay that she faces now is just a fact of history, and that's a reasonable defense in Mississippi. I think this lever is also pretty obvious to many of us from the activities of the National Labor Relations Board over the last several years. And so I think we all know that the National Labor Relations Board, at least for a segment of our workforces, would frown upon preventing employees from discussing their wages and obviously terms and conditions of employment with each other. That would likely be an unfair labor practice. This lever also has different provisions, things like you can't ask about salary history, you can't punish someone for talking about salary history, you can't punish someone for refusing to talk about salary history. And so basically these laws generally say, stay away from it, don't ask about it, and don't use it. But if your employees want to talk about their comparable salaries and perhaps engage in concerted protected activity, that's okay, and the employer has to stay away from it. There are some laws that make what I think is a really good carve out, and I think it's probably a pretty obvious one. If you have employees that are in possession of salary information or salary history information as part of their jobs, like an HR person, that HR person is not free to disclose this kind of information about other employees. These laws are really targeted at me disclosing my own compensation and my own compensation history to my coworker. The second lever that I've identified is pay transparency obligations. And by my count, I believe there are 21 states and localities that have laws related to pay transparency. And here the theory is knowledge is power. Everyone should have the same information about what the pay opportunities are at an organization, have the same information about what they need to be negotiating to come into a role, what they might get if they have a promotion into a new role. And basically, all that information is available to everyone, and so we all start from the same level playing field. I am from Denver, and I believe that it's really Colorado that's led the states in this pay transparency lever. And in 2001, Colorado started this pay transparency wave by requiring salary and benefit ranges to be posted in job postings and also promotional opportunities advertised to current employees who might avail themselves of those opportunities. So Colorado started it. We went through a wave of employers not doing it and then doing it, but posting such a large range, it was not useful. We went through a phase where some employers would post a job, but say Colorado applicants need not apply in an effort to avoid the pay transparency provisions. But in Colorado, at least, that has started to settle down. And I have some statistics I'll share in a bit about how it's working in Colorado. According to Indeed nationally, by August of 2023, last August, half of US job postings on their site included some kind of employer-provided salary information. Again, there are variations in these pay transparency laws. One of those variations is the size of the covered employer. So in Colorado, if you have at least one employee in Colorado, you are obligated to have your job posting contain the relevant information. Massachusetts, I believe, applies to employers of 25 or more. Minnesota, it's 30 or more. So in each state that you're doing business, the applicability of this kind of a law is going to depend on the size as defined in the laws. Each law treats remote workers differently, and so that's really a separate webinar in and of itself, how to consider remote workers for purposes of pay transparency. Some of the laws require disclosure in job postings. As I said, Colorado. Some only require information upon request of an applicant, and that would be something like Maryland or Rhode Island. And in Nevada, if somebody is interviewing, you need to disclose the pay range to them as part of the interview. The scope of what needs to be disclosed is different in various states. So Hawaii, I believe, requires just the disclosure of salary or wages. In places like Colorado, Illinois, and Washington, you have to disclose the compensation plus some level of detail about the benefits that are available for the position. Some of the laws require disclosure just to applicants. Some require disclosure internally as well. And then some of the laws are just agency enforced. So that's in Colorado. There's no private right of action. But in some states like Illinois and Washington, there is in fact a private right of action. And so as a result, what we are seeing in a state like Washington is that individual job seekers are entitled to sue a prospective employer over a defective job posting, and they can get at least $5,000 or the actual damages suffered. And so Washington is seeing a lot of putative class actions filed over this. Taco Bell, for example, had 8,000 applicants settle a class action for $2 million. JB Hunt had 2,200 applicants settle for $4.2 million. Qdoba, there was a settlement reported of up to $3.8 million. And so what that means in a state like Washington is that you better be darn sure that your job postings are completely compliant. I'm not sure this is what the Washington legislature intended, but it certainly has opened the floodgates, at least at this point, for pay transparency violation cases. So then the next lever is equal pay laws. And the Federal Equal Pay Act, as we've talked about a little bit earlier today, is a way that the EEOC can enforce equal pay or pursue equal pay. But the explanations or the excuses that an employer can offer for why there is unequal pay between similarly situated people include a catch-all that's called any other factor other than sex. And so an employer can say, well, there's some other factor other than sex, which is the reason why we brought this person in at a higher rate. And an example of that might be a market condition. So it's super hard to find RNs right now, so we're hiring them now at a higher rate than we did 10 years ago. And so there is pay disparity between the RNs based on when they were hired. 49 states, I could not find one in Mississippi, 49 states have their own equal pay laws. Most of them follow the federal EPA, which means there's that same broad exception or defense. But we are seeing some variations in states like Colorado, New Jersey, Oregon, and South Dakota, where there is some limitation on the acceptable excuses or defenses that can be offered by an employer for unequal pay. In Colorado, again, for example, the any other factor defense has been limited or eliminated. So in Colorado, it has to be tied to one of 7 specific factors, including, I don't know them off the top of my head, but responsibility, time in role, those kinds of things. But you don't have this other catch-all that you can use to argue a market condition necessarily. And then there are different safe harbors in some of these state equal pay laws. If you are conducting pay equity audits and remedying or trying to remedy disparities, in some states you can use a recent audit as a defense to some or all of the damages that may go with that kind of a claim. Is it working? So here, according to the Colorado Women's Foundation, they did a study since 2021, which is when I mentioned the Colorado law went into effect, and that has both pay transparency and equal pay claim provisions in it. And according to the Women's Foundation, Colorado's pay equity ranking has jumped from 21st smallest gender wage gap to the 6th smallest gender wage gap in 50 states. Pay for women in Colorado has increased from 78% to 85%. The study revealed that the gender wage gap is closing in Colorado because women are being paid more and not because men are being paid less. And then Colorado, since 2021, according to this study, has reduced its gender wage gap more than 3 times faster than the rest of the United States. So the Colorado Women's Foundation would say it's working. My last lever is what I'm calling certification obligations. And to me, this means that there is skin in the game for the employer. And Illinois is really the leader in this space. So in Illinois, businesses that have 100 or more employees have to apply for an equal pay registration certificate. And that certificate has to be signed by a corporate officer, legal counsel, or other authorized agent. And this started in 2022, I believe, and employers have to recertify every 2 years afterward. But this is a time when the leader of the organization, the corporate officer, the legal counsel, the authorized agent, have to represent publicly to the Illinois government various information about the workforce. And that includes certifying that the employer is in compliance with the Illinois Equal Pay Act and other relevant laws like Title VII, the Federal Equal Pay Act, the Illinois Human Rights Act, and the Equal Wage Act. And so they also have to certify publicly the approach to the business takes to determining wages and benefits, the average compensation between female minority employees and male non-minority employees is not below average when you do a comparison, that wage and benefit disparities are corrected when they are identified, how the business identifies or sets up its wages and benefits, and many other things. So the Equal Pay Registration Certificate is the end goal of what you're trying to get. And in Illinois, there's a whole regulatory process set up on the front end. This is before anybody has filed any kind of a complaint, where the leader of the organization is signing a certification, providing information, and then there are a number of outcomes that could come from this. One of them is that the certificate is issued, but it could also be rejected with an opportunity to cure. If the certificate is ultimately rejected, then there are appellate rights. And the certificate can also be revoked by the state if they determine there's been a lack of good faith effort by the employer to promote and clear up equal pay issues after an investigation and reasonable cause. So I believe that this front end loading of information and requiring the top of the organization to pay attention and sign something is probably the kind of the gold star at this point in what we're seeing with these pay transparency levers. I think we're going to see more and more states and localities go to this kind of a format. New York City has proposed a piece of legislation that has not passed yet, but that would be very similar and even further reaching to what Illinois is currently doing in terms of getting a pay registration certificate on the front end. So before I go to kind of the things that multi-state employers should be considering, I have poll results here on this whiteboard. And for question number 1, it was how recently have you conducted a pay equity audit? And only 29.2% answered within the last year. So I don't have all of the percentages in front of me, but that leaves quite a few people who either are doing it more frequently, which is great. 2 years under Colorado, a 2-year audit period is sufficient for a defense. But I suspect if I could see the answer to D, there are probably quite a few organizations that are still trying to figure out what this all means and maybe haven't embarked yet on conducting a pay equity audit to find out what they don't know. Question number 2 then was, where does pay equity reside within your organizations? How far to the top are people talking about it and paying attention to it? And more than half of you, 55.2%, answered that pay equity and pay equity issues reside with HR. And so I don't see the answers to the other questions, but to me, that really begs the question of whether HR has a line of sight to the top of the leadership in the organization, whether this is something that's being discussed at the C-suite. For those of you who are employers in states other than Illinois, what would happen if you took all of your pay information and this registration certificate to your CEO and asked him or her to sign it, So it could be filed with a government in Illinois. How would that person feel about it? And how much through the organization has the importance of pay transparency and equality permeated? So I think my final point here is I do a lot of work with employers that have employees all over the country. And as more and more laws seem to be driven at the state levels, whether that's paid sick leave, or in this instance, pay equity, pay transparency, I think it gets harder and harder for multi-state employers. And so I think that there are some decisions that you're going to have to make. As a multi-state employer, do you take a state-by-state approach? Do you alter, for example, your job posting, depending on where the position will be? Do you have different interview scripts or different applications to deal with salary history disclosures? Or do you choose a one-size-fits-all? Maybe you are disclosing more information than you technically have to a part of your workforce, but administratively, is it easier to choose the one-size-fits-all? And what's the harm necessarily in sharing more information with some of your employees in the less aggressive states if you already have to share it with employees in places like Washington, California, or Colorado? I think it's important to decide whether you're going to focus on best practices or legal requirements. Again, what is the best practice for ensuring pay equity? The best practice is probably to conduct an audit under attorney-client privilege. It may not be a legal requirement in your state, but certainly it is becoming a best practice so that you know what you're dealing with. You need to pay close attention to fast-changing legal developments. It seems like every year we have a new state legislature considering this. We've got New York City, we've got San Francisco, we've got different kind of progressive cities taking on pay equity themselves. And so the legal landscape is changing. And I think if I talk to you again next year, my numbers would change as well. And then my final piece of advice, particularly given that only 30% of you have within the last year been involved in a pay equity audit, I would say that you really need to find out how bad it is. Hiding your head in the sand is not going to be helpful. Find out what you have, do it under attorney-client privilege so you're not creating a report that the plaintiff will have. Fix what you find and then document. So if you find a pay disparity, you need to document and research why that is and make sure that you can prove that this person has an advanced degree or that person has different job responsibilities, and so the pay should be different given the level of responsibility. I'll conclude by saying there are the legal requirements, and then there's also the employee expectation piece of this. And as more states and jurisdictions pass these kinds of laws, as more and more job postings on Indeed contain the pay transparency information, employees are coming to expect that. And I think will question when they're not getting that kind of transparency from you. And I've actually heard employers say that the more transparent and open and obvious they can be with people about this, the easier it is for them as well. You're not, for example, walking into a job interview having no idea that the person expects twice as much as the range that you've sketched out for that job. This way, all the information is out there ahead of time for both the benefit of the employer and the employee. So with that, I will turn it back over to AJ to slander another one of my colleagues. Thanks, AJ.
Thank you, Barb. As you've probably been able to tell from the presentation so far today, particularly my portions of the presentation today, credibility and candor are the most important aspects. And so when Barb, after my introduction, suggested that I needed to fact check the things that I had said about her, I did. Spent most of the last 30 minutes contacting people in Denver and near Denver, finding out if the legends that I had passed along were true. And each and every one of them was confirmed. There was one thing that I did say that maybe wasn't as accurate as it could have been. And that's when I said that Barb Grangine was like a good lawyer, because everyone confirmed that, in fact, she's a great lawyer. So I do apologize for that. And if I make any other mistakes or if I identify anything else like that, I certainly will let you know. But we're going to move. This is our last break before the final presentation. And so we're going to hear from a California colleague of ours about California law in 2024. At this time of day, our clients and contacts out on the West Coast are awake and paying attention, I'm sure, not so early as it was this morning when Joe and Scott were talking about wage and hour at what was like 7 o'clock local time for you Californians. But instead, we're going to be talking now with Rob. But before we jump to his presentations, this is Robert Huddock. He is a new attorney, relatively new attorney to Husch Blackwell. We're very excited to have him join us and expand our ever-growing capabilities in California, where employment law rather is its most complex and interesting. But Robert is a complex and interesting person. And so one aspect of his experience, his personality that maybe isn't obvious, although perhaps you can look at that photo and you can connect the dots, but he is a very accomplished, or at least a very experienced triathlete. So I used AI to say, what would Robert Huddock, the lawyer competing in a triathlon, look like? And this is what they came up with. So riding the bicycle, I think they call that business on top, athlete on the bottom as he competes against a number of AI-generated competitors. And he looks like he's in the mix. Can't tell if he's in the lead or not, but he's certainly not at the back. So doing his best. Whenever I think about triathlons, I'm always reminded of the old statement that sharks obviously swim faster than men, but most men are able to run faster than sharks. So the triathlon will come down to who does better on the bicycle. So I think that's a good way to think about the world, and a good reminder that as much sense as that made, California employment law tends to make less. And so we're going to send it now for our last substantive presentation to the other studio and Robert Huddock.
Good afternoon and welcome to the home stretch of our program today. As AJ mentioned, I am a partner in the California office and I am a labor employment attorney. So today I'll be talking to you about legislation that has been enacted in 2024. I will be spending the most time today on the subject that everyone is talking about, and that is PAGA reform. That just went into effect 2 months ago. In addition to PAGA reform, I'll be covering a subject that we've been getting a lot of calls on, and that is the Workplace Violence Prevention Plan requirement. And I'm going to provide you with some simple ways, what hopefully will be simple ways for you to comply. In addition to that, I'll be talking about the increase in California minimum wage and what that affects besides the minimum wage itself. What are the implications? I'll be talking about enhanced sick leave, also enhancements to retaliation provisions. There's a presumption that now applies. I'll be telling you about some new requirement for the California wage notices, and I'll be directing you to the model notice that the DLSE has published. And if there's time, we will talk about the new laws that relate to cannabis use and also leave for reproductive loss. So let's get right into the PAGA reform. The question that may come up in your mind when you hear about PAGA reforms, given that it's been around since 2004 and we're getting reforms now 20 years later, is why now? And the short story is that there was a pro-business political action committee which got some traction with putting a ballot measure on the November 2024 election. And basically speaking, it would eliminate PAGA and put in an entirely new statute, and which would be questionable as to what kind of teeth it had. The pro-employee legislators realized that this could have, the ballot measure could be successful, and so they got busy negotiating a deal that was sufficient for both sides. And this is what they came up with. But before we get to that, I want to mention that these reforms are applicable to all LWDA notices that are filed after June 19th, 2024. And as it says on your slide there, the subjects addressed are standing, penalty caps, wage statement violations, and if we have time, we'll talk about cure and early resolution procedures. So what I like to do in my presentations is I like to give my clients a balance between digestible information and information that they can refer back to should they want to later. And so what I've done is I've created a table with respect to these PAGA reforms. And down the left-hand, the most left-hand column, I'm listing the subjects that are in the PAGA reforms. In the second column, I'm listing what the existing law was before these went into effect. In the third column, I'm talking about what the new law is. And then in the last column, I'm talking about things to think about going forward with respect to these PAGA reforms. And there is material that's available to you that has a little bit more information than these slides or this table. And always you can connect with your human resources professional or your labor employment attorney to ask any questions. So let's get right to it. And the first subject is standing. Who can bring a lawsuit and for what scope of claims? Prior to the reforms, the standing rules were very broad. And what they were is, if you had a plaintiff who suffered or who allegedly experienced any violation at any time, that employee could bring an action on behalf of himself or herself and all other aggrieved employees within the statutory period of 1 year. And they could bring that claim for any violation, even if they didn't experience it themselves. And so what the PAGA reforms have done is cut that down significantly. And what they've cut out is the ability of an employee to have standing if the violation that they experienced was more than a year before the LWDA notice. If they experience anything within 1 year, then they potentially have standing. But what they have standing for is only those violations that they themselves experienced. And so an evaluation question is, will this reform result in a reduction of PAGA claims? And here, when I say PAGA claims, I'm talking about the claims of every aggrieved employee. And with that definition, the answer is yes, because as you can imagine, if you have an employee who can bring claims that he or she themselves didn't experience, that can broaden the scope of claims that can be brought, and also it allows the employee's attorney to do widespread discovery and make litigation a lot more difficult and costly. They just can't do that anymore. Again, they have to experience a violation within 1 year of the LWDA notice, and they need to have experienced that violation or the violations they actually experienced within 1 year of the LWDA notice. In a lot of cases, we have folks that are within those requirements. In other words, they're only bringing, before the reform, they're only bringing claims for violations that they themselves experienced, and that they were recent enough employees that they're in within 1 year. And so in that sense, you're not going to see necessarily a big reduction in PAGA claims wholesale, but definitely those claims that were broadly widening exposure. Now, there was a case decided in late 2023 that, putting it simply, said if there is an arbitration agreement between the employer and that employee, and the employee brings in court both individual and class action claims, then the individual claims need to be brought to arbitration first in order to decide the validity of the claims with respect to the individual plaintiff, and whatever is determined to be not valid in the individual arbitration decreases the scope of what they can bring in a representative action when they go back to court. And that has a lot of advantages. Like I said before, with respect to discovery, you have the opportunity to limit the scope within an efficient procedure within arbitration, and hopefully prove that in the arbitration that not everything that they claim is valid, and then you can significantly decrease the scope of the representative action. Moving on to the next subject, we have penalty caps. And this involves a concept of there is a cap on penalties when all reasonable steps to comply were or are taken. Prior to the reforms, there were no limitations on penalties. And it was just the standard $100 or $200 per employee per pay period, regardless of the type of the claim or the claims that are brought. And so what these new caps do is there are caps of either 15% or 30% based on when the employer engaged in the steps, the reasonable steps to comply. If it's before the LWDA notice, it gets reduced to 15%. If it's after the LWDA notice, it gets reduced to 30%. And when we talk about 15 and 30%, we're talking about 15 or 30% of the standard 100 or 200. And just as a reminder, well, we're going to get to the 100 versus 200 later because that's another subject that's covered in PAGA reform. So obviously the question becomes, what are reasonable steps? And that question is left somewhat open, but the legislature did include in the PAGA reforms examples of what might constitute reasonable steps. And the examples that they list are periodic payroll audits, disseminating lawful written policies, training supervisors on wage and hour compliance, and taking appropriate action with regards to supervisors who are using improper practices. The law says that it's going to be a case-by-case basis, the evaluation. It's going to be based on the totality of circumstances. And the courts will also consider in making their evaluations the size and resources of a particular employer and the nature, severity, and duration of the alleged violations. There's one difference in the 15% penalty. There's one additional, not additional requirement, but an additional term to consider when thinking about the 15% the reduction down to 15%. And that is, with that reduction, not only is it before the LWDA notice, but it is also before any request for wage and hour employment records by the employee. And that request can come at any amount of time before the LWDA notice. So best practices there is to start paying attention to compliance now and have that usable as a defense, as it always has, and also to be able to try to reduce the penalties down to 15% of whatever the standard penalty is. Now, with respect to this, there are, just like all reasonable steps, there are other terms that have ambiguities in these statutes. And the concern is that, is there going to be as much or more litigation over the interpretation and application of these terms? We will see. And there's also, we can also discuss strategies for establishing reasonable steps, for establishing that you did take reasonable steps to comply. And one thing to do is focus on those 4 examples. Focus your efforts at compliance on those 4 examples, because obviously then you can point to compliance or those steps in any proceeding where you're trying to show that you took reasonable steps. Now, what do you do now? What can an employer do now to enhance their defense or to have that reduction in penalties? And what an employer can do is conduct an inventory of all their wage and hour practices and review these and their policies, consider possible additions and enhancements, and also implement all newer enhanced policies and practices that are feasible as soon as possible. Because then you'll have them in place for a long time before there becomes any issues, or for the longest time possible. What steps can you take after LWDA notice? One thing I want to note here is that the time within which to take reasonable steps after the LWDA notice and get that reduction down to 30% is 60 days. And so especially with this reduction, you're going to want to get right on to doing whatever you can do in that 60 days, because that's all you've got to implement anything new or do anything new, and then have that proven. So I just wanted to make you aware of that time limitation. And again, so since there is that short time period, what you should do if you receive an LWDA notice is immediately consider, develop, and implement newer enhanced steps to comply. And also, the earlier you get on it, it demonstrates importance. It maximizes that amount of time that you can show that it's been in place, and possibly you have some positive results that you can offer. And again, it may already be clear, but when we talk about, the law talks about percentage of penalties sought, ultimately what it really means is for 15%, and the fee is $100, you're down to 15 instead of 100. For 30%, it's 30 instead of 100. Let's move on to the next subject that's covered, and that is wage statement violation penalty caps. Prior to the reform, there was no limitation. You had the standard $100 penalty for all wage statement violations, and that was for even the most technical violations, like having the incorrect name of the employer address on the wage statement. PAGA reforms changed that. And there's 2 possible limitations, and that is you can limit the penalty amount to $25 per employee per pay period if the employee can, quote unquote, promptly and easily determine the wage statement information required despite the error. And I have an example from personal experience that I can offer to you. I had a client on whose wage statements the beginning date of the pay period was listed. It listed that the pay period was 2 weeks in length, biweekly, and it didn't list the final date of the pay period. And that was a violation. Believe it or not, there are 2 California cases that specifically address this issue and find that these circumstances set up a violation on every single wage statement just for that. Well, the PAGA reform doesn't take care of that completely, but it does reduce the penalties available to $25 instead of $100. What are some further examples of circumstances where an employee can promptly and easily determine the wage statement information despite the error? Let's say that, well, first you have well, we'll cover that later. But one example might be if, for example, on the hours listed, if there was a misdesignation, there was an improper designation in the wage statement that indicated let's say there's 2 designations for straight time, when you could figure out by calculating, going backwards in the calculation, that the rate that's listed next to it is 1.5 times the standard rate. And that's where they can determine that this was overtime. The other reduction that employers can get is where it's $50 per employee per pay period instead of $100. And this is a little bit different circumstances. And this is for, quote unquote, isolated non-recurring errors that last less than the shorter of 30 days if the employee can promptly and easily determine the wage statement information. It's for isolated non-recurring errors that last less than the shorter of 30 days or 4 pay periods. And an example of where this might come into play, you might have a new payroll employee that changes something with respect to how the payroll is done, and it's quickly noticed. And there were 4 pay periods in which there was an error due to whatever change that new payroll employee made. Well, that is no longer going to be a $100 penalty. It's going to be half. It's going to be $50. Let's go to the next one, which I think is a significant reduction in amount of exposure, because this was not a common practice, but a universal practice. And what I'm talking about is derivative penalties. And let me explain what derivative penalties means. To give a definition, it is additional penalties that are awarded based on the same underlying conduct. Let me put it into context. Meal periods. If you had if there was a failure to provide a meal period and there wasn't a payment of the 1 hour of premium pay, that one act could set up 4 different penalties. You'd have the first penalty for not providing the meal period and not paying the $100 premium. Next, you'd have a wage statement penalty, because the theory being if you didn't pay the 1 hour premium pay, then the wage statement is inaccurate and there's a penalty for that. Another derivative claim in this situation would be where you have failure to pay all wages due and owing at the end of termination. And if the theory here being, if you missed a pay period and you didn't pay the premium, then you didn't pay at termination all wages due and owing. And so that tacks on a penalty, and it also tacks on penalties for up to 30 days of a daily wage for not paying all wages due and owing at the end of employment. And then finally, there is the California provision that says employers need to pay all wages due and owing at the end, by the end of each pay period. And the argument is the same. If there wasn't that payment of premium pay that was due, then you haven't met the requirement for paying all wages for the pay period at the end of that pay period. So there is a fourth penalty. The PAGA reforms take care of this, and they basically take out derivative penalties. Derivative penalties are not going to be something that a plaintiff can get anymore. And as with most law, there's a caveat, and it's prohibited provided that the inaccuracy or incompleteness in the statement was not knowing and intentional. And so that's with respect to wage statements. So there's two different derivative penalty rules. One is with respect to wage statement violations. The other one is with respect to failure to timely pay violations. And with respect to the failure to timely pay penalties, those are now prohibited, provided that the underpayment similarly was not willful or intentional. Obviously, you can see where there might be a dispute over what is, or a need for definition of what is knowing and intentional, or what is willful or intentional. And there are some regulations with respect to other laws, such as final pay, where there's some further definition of what is willful or intentional. But to get into that law and further into that definition is beyond the scope of what I can cover here today. Let's move on to what I mentioned before, which is the penalty structure that the PAGA currently has, and will still have, but there are different rules that apply. In the past, what plaintiffs' lawyers argued, because what it talks about is it's $100 for the initial violation per employee per pay period, and it's $200 for a subsequent violation. And what plaintiffs' attorneys would argue is, well, when you talk about initial violation, you're talking about a violation in the first pay period. If there was a violation in another pay period and every pay period after that, then it was $200 per pay period from the second pay period forward. There's at least one case that disagreed with that, and that's what the PAGA reform did, and that is to say there is an initial violation for purposes of PAGA when a government body or court has determined that a practice was violative. And it's only if that issue is brought up again in a proceeding that the penalty goes up to $200. And that's essentially what the law says. It basically codifies what employers would always argue, and it makes clear what the cases have said, at least some cases have said, with respect to when you use the 100 versus the 200. And like I said, in addition to the slides, all attendees will have access to a PDF document that has some more information than what's on these slides, so it's available for you to look to see that additional information or to refer back to. Now, there was a wrinkle in the PAGA as it existed, in that employers with weekly pay periods ended up paying twice as much as employers that had semi-monthly or bi-weekly pay periods. And what the PAGA reforms do is they eliminate that. And it's the employers with weekly pay periods pay only the same as those with semi-monthly or bi-weekly. The other thing that the PAGA reforms change is the share of penalties. The share that existed prior to the reforms was 25% to the employee and 75% to the LWDA. It's shifted a little bit. It's now 35% to the employee and 65% to the LWDA. Another thing that's added by PAGA reform is that now injunctive relief is available as a remedy to a plaintiff bringing a PAGA claim. What is that going to be? We don't know yet. What could it be? Maybe it's to enjoin ongoing wage and hour violations. Maybe it's to restore unpaid wages. Maybe it is to mandate training. And maybe it's requiring workplace postings. But it remains to see if that's widely used, or if it is used, what relief are they going to seek through an injunction? Now, there's two additional things that the PAGA reform covers. Some people refer to, we talked before about the 15% and 30% penalties. Some people refer to that as a cure. But for purposes today, I'm going to talk about a cure that, if satisfied, an employer can avoid litigation altogether. And the way it works is this. If the employer takes all reasonable steps to comply with the allegedly violated labor code provisions, and, well, let's back up. The scope of violations that are now included in those that you can cure, because there was an existing cure provision, they're now much wider. So, for example, there's a wider scope of wage statement claims that can be cured. And most importantly, it adds all together the typical violations that you see in PAGA cases. That's your meal and rest periods, it's your overtime claims, and it's your failure to reimburse expense claims. And so all of those now are subject to be able to being cured. Now, the cure with respect to, there are two cures at play here. One is with respect to wage statement violations. The other is with respect to those other three that I just mentioned. So let's talk about the wage statement cure. Now, I talked before about an incorrect name of the employer or address of the employer. That can now be cured by providing providing your employees access electronically, for example, to a summary of the corrected information and a listing of all the pay periods on which the wage statements had the incorrect information. And then for other technical violations, an employer can cure those by providing electronic access to corrected statements, whereas before you didn't have the option of doing it electronically. And as I mentioned, if successful with these wage statement cures, then plaintiffs simply cannot make that claim in litigation or in their LWDA notice. With respect to the other three, we're talking about payments. And the requirements for successfully invoking the cure provisions when we talk about meal and rest periods, overtime and failure to reimburse, are that the employer end whatever practice caused the violations, use compliant practices going forward, and you make the aggrieved employee whole. There are provisions in the statute that cover what it means to make the aggrieved employee whole, but I do want to continue on to some of the 2024 laws that are important to hear about in the time that I have left. Now, as I mentioned before, we've received a lot of calls on the Workplace Violence Prevention Program, the requirement. And what this is it's an outgrowth of the existing requirement for the Illness and Injury Program that's been around for a while now. And with respect to the requirements for the Workplace Violence Program, there are 4 general requirements, and I have these here in the slides. Number 1, create and implement a workplace violence prevention program that meets requirements enumerated in the statute, and we'll come back to that. The second requirement is maintain records regarding the workplace violence protection plan. The third is provide effective training. And the final is record violent workplace incidents or threats. Let's go back to number 1 and talk practical. Create and implement a workplace violence prevention program. The simplest thing to do with respect to that is Cal OSHA has published a model plan that, and it's in Word format, and you can use that document as the foundation for your plan. You can tailor whatever is in the model plan to your business. And since it's based on the model, that's going to be something that complies with the requirement. The next requirement is maintain records regarding the workplace violence prevention plan. And all that means is that you need to provide a copy of the plan and have one available to all employees at all times. If you have an intranet, that's the simplest way to comply with that. And you can also have it as an onboarding document. That's another way. Or you can send it out by email, whatever way that you can make sure that all employees both have a copy to begin with and it's available to them at any time. With respect to number 3, provide effective training. There are third-party vendors that have programs that provide everything you need from beginning to end for training for this program that is compliant. It has ways of making sure everything's compliant. It has ongoing training, periodic, and that type of thing. And that's going to be a simple way for you to be able to comply. With respect to record violent workplace incidents or threats, there is no model plan, but the log can be like any type of incident report. And you'd include such things as the date of the incident, location, time, short description, parties involved, witnesses, internal investigation, actions taken to prevent, and things like that. And not all of those are required. These are just suggestions. And then the final requirement is that you keep any such incident log for 5 years. And right there is the Cal OSHA model plan. And this is just the face page. I wanted to just show you what you're looking for if you want to use that model plan. Minimum wage increase. The state minimum wage went up to $16 as of January 1st, 2024. There are certain industries for which the minimum wage, the state minimum wage, is higher. Fast food is $20. Healthcare facility employees are some wage between $18 and $23 per hour, depending upon the type of facility. Now, remember that California has many municipal ordinances for minimum wage, and all of them are going to exceed even what is now the California state minimum wage. So you have to pay attention to the cities in which your employees work. Independent of that, with respect to determining for the purpose of exemptions and the salary test for exemptions, what you consider is not the local minimum wage, but the state minimum wage for purposes of determining whether the salary threshold is met. And the salary threshold is 2 times minimum wage, but it is state minimum wage. So since the state minimum wage went up, your the salary threshold is commensurately going to go up. And what $16 brings it up to is a total of $66,650 annually. And with respect to the fast food and the healthcare, fast food is just going to have $20 as the basis, and healthcare is similar, but it adds something. There are what the threshold is one of 2 things. It's either the 2 times the standard minimum wage of $16, or it's 1.5 times the healthcare wage, that wage between 18 and 23. And that 1.5 times start to exceed the $66,650, right around $21.50 per hour. Let's talk about enhanced state sick leave. As of January 1st, 2024, it increased from 3 to 5 days. There are still the same ways in which to give employees their sick time. It's just going to be the increase to 5 days. And those 3 ways to provide are front loading. That's when you give employees all their sick time at once at the beginning of their employment, and then for subsequent years at the beginning of any 12-month period that the employer designates. That could be work anniversary or any other 12-month period, such as fiscal year, that the employee chooses to use. Then there is an accrual method that is specified in the statute, and that is 1 hour of sick leave for every 30 worked. And that's starting on the first day of the 12-month period. It needs to carry over. And here's the difference. When you use the statutory accrual, it's now the cap is 10 days and 80 hours instead of the 5 and 40. And then there is, we talked about the salary threshold. Well, the other acceptable accrual. And that is the type of situation where, for example, you provide PTO that is at least as much as the amount of sick time that's required. With respect to this, the difference between the statutory method and whatever method you choose that complies is there's an additional accrual rate requirement, and that's highlighted in gray on your slide. And the accrual rule there is you need to have an accrual method that where they get to accrual of 5 days and 40 hours within 200 calendar days of the start of the 12-month period. And efficiently using the time that we have left, in 2024, there are whistleblower retaliation presumptions with respect to certain labor code claims. And what we're talking about there specifically is the 3 things that are mentioned there on your slide. And these are based off of 3 different labor code provisions regarding retaliation. And to state it quickly, what there is if whatever adverse employment action, if after the alleged adverse employment action, it happens, they're terminated. Let me back up. In every retaliation situation, there is something called protected activity. And with respect to that, it's going to be such things as complaining about a certain practice, refusing to engage in a certain practice. And what the presumption says is if there is an adverse employment action within 90 days of that exercise of protected activity, then there's going to be a presumption that it was retaliation. But that presumption can be rebutted by the employer by stating a legitimate non-retaliatory reason for the adverse employment action, at which point the burden shifts back to the employee to show that whatever reason was given by the employer is merely pretext. The real reason is whatever they claim. Again, moving quickly. Wage notice. Some of you may be familiar already with the Labor Code 2810.5 notice. And there is an additional requirement now with respect to a disaster and emergency disclosure. Easiest way to comply with this is you may have been using the model notice already, but now there is a revised model notice and it has that disclosure in there. It's available online, and if you use that, then you've already taken care of it. And there I have an example of it. We've got about 1 minute left. These are the additional legislative laws that went into effect in 2024, and they relate to what's listed there. Some of you may have already covered that in that these went into effect at the beginning of 2024. But again, if you're interested in more information about these new laws, feel free to contact your HR professional or your employment attorney, and all of us will be happy to explain that to you. Thank you very much for attending, and I hope to speak to you in the future.
Thank you very much, Rob. And we are officially at, as boys to men would say, the end of the road. Thank you for joining us for part 2 of our Labor and Employment Virtual Day. As a reminder, the program has been approved for HR and legal continuing education credit. Make sure that you click on the continuing education button, at the bottom of your screen in order to register and get credit. You'll receive a certificate of attendance tomorrow that will come with a link to the videos for this second part, and you can share or rewatch at your will. Be sure to complete our short survey. It does help us to receive your feedback on today's program and things and topics you'd like to see in the future. And other than that, I appreciate all of you for attending, and this concludes our Labor and Employment Virtual Day. Thank you.